Please, Lord. Also, I'd like to mention item number 45. I've taken the consent of the counsel for the SBI. The certain instructions pending from the petitioners, my lord.
45 is the request made by the listed afterward.
I'm grateful, my lord.
May I please your lordship, with the consent of the other side, I beg to mention item number 43. Pass over for the day, lordship.
On whose behalf
Mr. M. Sharma, lordship.
have you informed the other side?
Yes, lordship.
43 stands past the day. The request made by
S. Yasmin on behalf of M. Sharma. For respondent.
yes, yes, yeah,
The respondent. Much obliged.
Yeah, my lord. Formalities are almost complete, my lord. Just before the committees can be final order could be issued, my lord. On 24/6, the income has been transferred out. When a new income has joined on 26/4, my lord. 26/6. Lord, so allow me 15 days time. In the meantime, every formality will be completed, my lord.
yes.
Pull it.
Steps are being taken. It will be able. However, meantime, the incumbent in the office of commissioner, what you mean? After that, the new and the present incumbent has just joined
On 26/6.
6/6. Therefore, praise the favor. To be
A date will fix, my lord.
after 2 weeks. After date.
Let you know on the first week of August, my lord.
No problem.
Anything.
On 6th of August.
Lord.
Right.
Problem.
Yes,
Lord, the respondent were directed to send instructions on to find an affidavit that this petitioner was suspended in 2000. Order is at my lord page 17. An employee, grade 4 employee of the Guwahati University. Then thereafter the order was withdrawn and he was reinstated in service. But Chief kindly see there were 3 persons on some imaginary ground they were suspended at page 20, my lord.
I think we have been given wrong file. Your case number is 378.
Yes, my lord. This number is P78.
I think a wrong file has been set. 3781 is before us.
That will be heard after some time. File may be brought
File to it.
because the petitioner, my lord, is 86 years old and is on a deathbed. That everything is given by the university
Call for it.
except the gratuity
Call for. We'll call it up after a while.
after some time.
May please your lordship. Lordship, matter burden the family pension and the pensionary benefit which has not received by the listener husband during his lifetime.
Lordship, the pension proposal is under process, Lordship. It may require some more time, Lordship. So let it be after 3 weeks, Lordship. In the meantime, Lordship.
The matter may be
My lord, what I am submitting lordship, my lord, I am for the respond number 9, 10 and 11 lordship. My lord, with respect to the pension papers lordship, that may be directed to be, my lord, disposed of within a specified period lordship. So far as my lord, other service benefit lordship, sorry, pension benefit lordship. My lord, in paragraph, my lordship, against that, my lord, the proportionate
You are appearing for
the respond number 9, 10 and 11.
9, 10, 11.
Yes, lordship. My lord,
The father and
my lord, sons
and the
and daughters, lord. So, my
And
lord,
who is the petitioner?
wife.
and wife.
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 lord, at that, to that regard, my lord, I have no objection, lordship. So this way, my lord, maybe disposed of. Only, my lord, problem is my proportionate share of my lord other service pension benefit, lord, pension benefit. If my lord the petitioner agrees, lordship, then it may be disposed of, lordship.
I am agree with you.
I legally hears, lordship. We are three.
Who is number 9? Number 9.
9 is lordship.
and 10.
Yes, lord. 9, 10, and 11, lord.
9 is son, lordship. Son of the disease. And another Joyanti Das.
Daughter. And third was lordship, father, lordship.
But
Father.
what are you praying for?
My lord,
Family
petitioner.
pension.
My lord, I am not praying, lordship. The petitioner is praying, my lord, for the pension and my lord other service benefit, pensionary benefit like gratuity, etc. Lordship. My lord, against the pension, I have no objection, lord.
You
Family
can't have
pension.
an objection. Your son is 33 years old.
My lord, as
Daughter
regards,
is married.
yes, I have no ground. Only, my lord, with respect to the my lord other pensionary benefit. Lord.
How are you?
Proportional share,
Under what provision are you entitled?
my lord, those are property lordship. Proportional share,
You show us.
proportional share, my lord, petitioner is agree.
Even if he agrees, we can't issue a direction. You go and sort it out. Show us a provision that you are entitled to this.
Then, my lord, the wife can claim family pension only, lordship.
Of course, he can claim
Others-
anything.
Every-
Other pensionary benefit, lordship,
Of course
we
you
are
can
also
take.
entitled.
He can claim.
Then that may be fixed, my lord, hearing law.
You show us that you have a case for claim.
Yes.
Petitioner
That may
agree
fix
that that is not, we can't issue direction to the departmental authorities. You are not
Entitled.
entitled under the rules.
Only on the other hand, we have, my lord, heard that we have to know that my proposal for proportional share has already been submitted lawsuit.
Let it be before the Lordship. Lordship, I am saying that is why I am submitting, Lordship. The
Ah.
proposal is on, Lordship. So let it be after 3 weeks. I will come with my affidavit, Lord.
Proposal for what?
Pension proposal is on, Lord.
Pension proposal for the
That
petition.
is the instruction, Lord. It's the instruction I am having.
Why 3 weeks is required here? Only I have to get the instructions whether
Lordship,
what is the status
after a
of
week,
pension proposal.
Lordship,
Get it after 1 week.
Lordship,
After 1 week, you
Already
tell us
lordship.
what is the status.
Lordship.
Third comes to the party.
What is that?
Irrigation. Submits that the pension proposal is already being forwarded. 6, 1 week time. Is 6, 2 weeks time.
Yes, Lord.
Update with status of pension. In respect of the claim made. considering that. Considering the submitted. Within next 2 weeks.
So in the meantime, I'll file out.
Rapid appeal for the respondent 8, 9, 10,
9, 10 and 11.
9, 10.
All right, Lord.
All right. Bullet.
As per the last order, latest judgment of the apex court, he is to be allowed till the time he reaches the pensionable age.
Perhaps Lordship is referring to the case of Sadhguru Singh.
I don't recollect the name.
If I may,
What is the judgment?
I'm just running over a copy of this.
My lord, I have annexed in my affidavit in reply, my lord.
Why can't you give us the date?
My lord, judgment and order dated 14 July 2000.
Not one day.
Yes. Annex are one of my affidavit in
Not-
reply.
Affidavit in reply to the-
My lord, one thing I beg to submit. They have filed additional affidavit, my lord, on 27, last day of vacation. I filed reply to that, my lord, reopening that yesterday. I have checked, my lord, my reply is not on record.
It is submitted by the counsel to the petition. The reply to the addition of affidavit filed by the respondents was filed on
14.
7. The same is not available in the case report. Without the data affidavit, it will be filed and to have the matter listed again on next week. Or
It can be on Friday, Lordship.
It-
Monday, Lordship.
23rd,
That's fine, Lordship.
23rd.
Lordship, in the hearing column, so
What is there to be heard? 4 rating entries does not automatically entitle
yes,
dismissal.
yes,
But there is
that
one,
judgment,
one area where we want to have your views, we put it
yes, that we have
Counsel.
brought it in our additional affidavit.
108.
Perhaps that will be covered by the judgment I have.
This I think is the latest judgment. Perhaps
I'll be relying on that.
Satguru Singh.
Like, they have annexed that in their affidavit in opposition, that judgment.
All right. But in affidavit, you're not supposed to enforce that. I don't know why
Uh,
started doing.
The
They-
difficulty,
Is to
how-
trace out the judgment.
no, Lordship,
time
the
of hearing.
difficulty which I am facing, Lordship, is the authorities would want the judgment to be there.
Tell them that
No, that has been,
you are the standing counsel.
that has been
You
communicated.
decide what goes in and what does not go in an affidavit. It's not 23rd.
In item
All
5,
meetings are complete here.
in item 5, your lordship. An affidavit. petition-
In all cases, affidavit have filed, only one cases, it is not coming from vetting, Lordship. Within 1 week, that is at last letter, 32, item number 32.
Have you filed any, are you filing it in jointer?
Yes, my lord. We have filed our rejoinder. In my case, item number 12, my lord. We have filed.
But in case of 5, your lordship,
Rejoinder file.
I have filed one rejoinder, your lordship, but one more affidavit in opposition has been filed. Well, I have received this copy one yesterday, your lordship.
Two affidavits.
Two affidavit, your lordship, because in first affidavit, it was only in respect of petition number 2. But yesterday, which one I have received, your lordship, that one in 5, your lordship. So in respect of petition number 2, I have already filed my rejoinder.
And the other affidavit is for petitioner 1.
It will. It. Five.
Which item is completed?
My lord, in my case, item 12, my lords, it's a pretty complete.
Then before 12, you're appearing in item 5.
Yes.
Who's in 6?
6.
Yes. Pleadings complete? Are the pleadings complete? Are you filing any rejoinder? Then what is the point in keeping it parted? Right, you complete your pleadings, we are giving you 2 weeks further time.
The councils of the other items are stating that they are not going to file any rejoinder affidavit.
Let the council say that why you
No,
becoming a council
they-
on behalf
they-
of another council.
My lord,
You submit on behalf of your
my lord.
matters.
Wait, your brother.
Yes, item 5, you are
but-
filing a rejoinder.
I have already filed in respect of petition number.
You are filing another rejoinder in respect
Another one
of
I
another
will not
affidavit.
file here. Another one I will not file.
You are not filing. Item 5, pleading complete. Here 6. 6, you are filing an affidavit. Are you filing or not filing? You are not filing. 6. Then 7.
My lord, in 29 lordship, I am filing
7,
lordship.
item 7. Right, item 7. 8. How many matters you are appearing?
11.
In these matters, what is the status? Are you filing? Your pleadings are complete?
Yes.
You give the numbers to the court mark. After that, 14. 14, who's appearing for 14?
My senior is on leave.
Okay, Mr. Ramet, your matter is 28,
Lordship. 29 lordship.
29.
My lord. I'll file lordship last sometime.
You want to file,
Yes, lord.
rejoin?
Yes.
Yes, and then
19, 23 and 28. I'm not filing.
19, 23 and 28.
8.
No rejoinder is required.
It's not prepared. Reading complete.
Reading the then item 22 also no rejoinder. Reading
27 completed. My lord.
27, reading complete.
No, item number 21, my lord.
21.
I will not file the affidavit here. I will file now.
Filing, not filing.
21. I will file.
21, rejoinder to be filed.
21.
Item 70. Item 17, your lordship. In here, the petitioner, he has not secured the card of mark here. So, item 17, your lordship, he has not secured the card of mark, your lordship. So,
I may be allowed to withdraw this, Your Lordship.
Item 17, on the request made by on the submissions of the learned counsel to the petition. And instruction that not secure the cut-off one. The petitioner does not wish to press the petition further regarding the petition dismissed from the calling. It reported the petty stand negated pending either of those.
Lordship, I'm appealing for item 18 and 25, the pleadings complete, Lordship. I have already filed my rejoinder. 18 and 25.
18 and 20, yeah.
Item 16, I shall file my rejoinder in within 1 week.
Item
16.
16,
এটা copy দিব।
rejoinder to be filed.
কোনটো item number?
Lordship, item 15, I am not filing.
Item
And in item 31, Lordship, I am going to. 32.
31, rejoinder to be. Yeah,
না, এটা পড়া নাই।
Lordship, in item number 30, I will file my reply, Lordship. Lordship,
readings
and
complete.
pleadings complete.
Item 30,
30.
readings complete.
No, I'll
Yes.
file my reply, Lordship. I'm yet to file my reply.
You want to file,
Yes,
then why do you say readings are complete?
yes.
Item 30,
Look,
rejoinder to be.
But in respect of item number 33, no affidavit in opposition has been filed by the respondent.
33 ফাইল কৰিছে নেকি?
And then,
মোক কৰিছো বুলি কৈ দিব।
yes, any more? Yeah, there are a couple of those matters where the pleadings are complete, sending. That forward, pleading, file going to the. Here. Matters we are things that we. These matters were getting on 31st of July. 31st, my lord.
All the matters.
All matters, but we'll take up only the matters which are where the pleadings are complete.
Fine.
Rest you may file it.
The first one.
All right?
Lordship, the interim orders for in cases may be continued.
Orders wherever parts will continue. The trustee.
How much?
Please.
So that- There's an IA file.
IA has been filed in item 35.
Vacating interim order.
Yes, Lordship.
This is the interim order.
The interim order was a stay on the disciplinary proceedings. Now,
That is dated.
Before my lord proceeds, I beg to submit one convenience note along with the interim order of the coordinate bench of Itanagar bench delivered by Honorable Justice Surana. And very recent order of this coordinate bench of this court. And the same matter, my lord.
What are you challenging below the report? What is your challenge?
My lord, there are three challenges, my lord. One is there is an inordinate delay in serving the memorandum in violation of CBC guidelines of 2000. The cause of action arose in 2020. They submit the memorandum on August 24, my lord. Firstly,
Memorandum of charges.
charges, yes, my lord. My lord, second issue is that the memorandum of charges is full of uncertainty and based on surmises and conjectures, my lord. And third and most importantly, my lord, I attract Army Act 177, read with Army Rule 180, wherein rather than conducting a preliminary investigation, one-man inquiry, they went ahead and conducted court of inquiry, thereby invited Army Rule 180, which says, my lord, if somebody is subjected to the Army Rule oblique vis-a-vis Army Act, and if there is the assassination of his character, then he should be given a chance to examine and cross-examine the vital witnesses. 1, 2, he should be present throughout the court of inquiry, and last, he should make his own statement. And this is a certain law by the Supreme Court decision, various decisions of Supreme Court. There are 3 judgments, which I which I have quoted in my convenience note, my lord. And second, as far as the vitiation of charge sheet, Supreme Court also has decided in this paper. And the cause of action, my lord, that is on 21st July to 1st July to 20th August 2020, my lord. And now, after taking 2 chances for filing a counter, they are moved an application for vacation of stay, showing the urgency of the matter. And my lord, this issue has attracted dual punishment, my lord, thereby attracting Article 21. And
Your counter affidavit is not filed.
I filed. Now they have filed it. I have filed the pleadings completed, my lord.
In,
Pleadings completed in both the cases, my lord.
in item lordship in WPC 19, that has been filed. Not a problem. In both the cases, it has been filed, lordship.
Right.
It has been filed, lordship.
Where are the charges? Charge sheet?
Yes, my lord. My lord, this is page 38 in my writ petition. That is the forwarding note, my lord. Charges article starts from page 40, my lord.
Which writ petition?
My lord, the writ petition 4861. Item 35, my lord.
Page number?
Page number 40, my lord. Before my lord have a look on this memorandum of charges, I humbly submit, my lord, this is entirely inconsistent with the terms of reference of Court of Inquiry, which was first held in August 2020, my lord, to find out whether there is a case or not. What they did, my lord, in 2022 April, there was a first recommendation of Lieutenant General. My lord, they did not stop there. They wanted to save the army personnel. And what they did, my lord, in July 2022, first held in 20th August 20, in July 22, they held the additional Court of Inquiry, my lord. Now that recommendation was given in April 24, my lord. And the memorandum is issued on August 24. See the chronological events, my lord. And because every day they change their opinion, they change the terms of reference only to facilitate the others against the law of equity, my lord. And I have been denied the chances to cross-examine the brigadier and the colonel who commanded my unit. He has been just simply got scot-free with a warning, my lord. And one captain, Vishal Mohan, my lord, who is a medical officer, he never called in the Court of Inquiry, my lord, who examined the casual paid laborers. The facts, my lord, if my lord permits, I'll tell in one line the facts of the cases, my lord. There are approximately 4,000 casual paid laborers under the command of 762 task force, which is commanded by Colonel Kaushik Mitra, my lord. I am working under him. I am the junior most officer, my lord.
You are employed with what?
I am employed as a OC RCC, my lord. and one is OCRCC Road Construction Company. Another is the assistant engineer, that time junior engineer of that RCC, my lord.
You are,
Bas-
you are employed under what?
Under Ministry of Defense, my lord. Borders organization.
From the PRO.
Yes, my lord. It is commanded by the Colonel 762 Task Force, which came under the project Vijay, which is commanded by the Brigadier, my lord.
Here.
Well, what happened? Because the recruitment took place by the project in consultation with the government of Jharkhand. And this payment is issued, released by the
We are not on that. You are essentially challenging
memorandum.
the proceedings itself.
Yes, my lord, court of inquiry, firstly, because that is the genesis.
Ah.
And they have admitted in their counter affidavit. Yes, they have come to they have issued the charge sheets based on the recommendation. I can draw my lord attention to their,
Where is the finding of the court of inquiry?
yes, my lord. My lord, there are two findings, my lord. And this is the finding that I did not have a copy of the finding, my lord. I have a copy of the recommendation, that too I just could manage, my lord. They have not provided a copy of neither a court of inquiry, copy of the court of inquiry, nor the finding, only the revised recommendation and first recommendation. First recommendation, my lord, I incorporated in my rejoinder affidavit, and the second recommendation I have incorporated in my writ petition.
Your submission is that first there has to be a finding by the court of inquiry.
Yes, my
And
lord.
only upon recommendation, there has to be a disciplinary.
Yes, my lord.
Under what provision of the rules of the act
180, my lord.
of
Rule 180 of Army Rule.
army rule? Your services are governed by the Army Act.
Yes, my lord.
You're an employee of PRO.
Yes, my lord.
PROs are under Army Act.
Army Act, yes, there is option. They can go ahead with the Army Act also. They can go ahead with the CCSs also. That decision has been given by the Honorable Chief Justice of the Supreme Court in 2017. Honorable Chief Justice Deepak Mishra, my lord. The order is with me. 2017 order. And earlier, our vision also passed the order in 2018-83, my lord.
Where is do you have any appointment orders to show how you?
My lord, I can produce my lord, the judgment of the Honorable Supreme Court, very comprehensive judgment of Justice Deepak Mishra. my
Yes,
lord.
Mr. Chaudhary, which rules govern the services?
Lordship, so far as the petitioner is concerned, it is a CCS.
CCS rule.
You know, my lord, this is the order. They can, they have proceeded, my lord, in the Army Act only, my lord.
And if it is CCS rules, then why court of inquiry?
Yes, that's the issue. If this is serious, I'm at.
We are interacting with it. We'll come
Develop.
back to you.
Lordship, the BRO now comes under the Ministry of Defense. But he is not a defense personnel. He is not a defense personnel. A court of inquiry is conducted only to find out some facts. Now, once the facts have been accumulated,
Inquiry concept under the.
Yes.
Relatable to the defense.
yes,
It's not a defense person.
he is not a defense person. So,
Why was a court of inquiry called for in his case?
yes, now,
Unless you say that they were working in tandem with the army personnel.
oh, they are working. Now, BRO is an organization where there are personnel from the defense and they are personnel from the civilian side as well. And he is from the civilian side. Now, to gather the facts, a court of inquiry is there. Once the facts are there, only after that, whether a disciplinary proceeding has to be initiated or not. And once a disciplinary proceeding is initiated, now in this case, a disciplinary proceeding has been initiated, a charge sheet has been issued, and he has participated there. He has, so far as my case is concerned, he has participated there. He has filed his written statement. Now he comes and challenges what Lordship will come to the prayer. He is challenging the memorandum of charges. And the law is well settled. Then you cannot challenge the memorandum of charges because that does not prejudice you. Once a penalty is imposed based on the charges after an inquiry, you can challenge that. And I'll just read out from so far as Lordship, the challenge to a memorandum of charge is concerned, Lordship, that your Lordship will find in 2012 11 SCC 565. I'll just
Before you proceed to the
Yes.
event, you show us the relevant rule, under what rule you have initiated the proceedings and what is his basis for complaint?
Lordship, here the proceeding has been initiated under the CCS rules. The memorandum of charges have been issued.
Yes.
And that if your Lordship will come to my affidavit, that is in WPC 19. And I'll take your Lordship to paragraph 9 thereof. From 8, Lordship, that is at page 80. Here is a case, Lordship, where payments were sought to be made to non-existent casual paid laborers. Now, that was sanctioned, and what the petitioner did was, once he came to know about the complaint, he again put it back in the treasury. If I may take your Lordship to page 80, my reply to paragraph number 6 of the writ petition, the deponent begs to submit that the assertions of the petitioner are unfounded and the petitioner is put to strict proof thereof. In the instant matter, there were complaints to PMO, white so-and-so, and CVC, white so-and-so, regarding false mustering of CPLs, that is casual paid laborers, in project Vijayak. The complaints were from an employee who was serving with 55 RCC and dealing with CPL matters. The recommendations for initiating disciplinary proceedings have been issued only after following due procedure as per outcome of vigilance check carried out by the department and outcome of court of inquiry wherein irregularities have been established prima facie. Then the next paragraph. It is submitted that a disciplinary action has been recommended against 13 officials of Project Vijayak. He is one of them. In both cases, there are two different petitioners. So the petitioner is not the only one against whom disciplinary proceeding has been recommended. As far as disciplinary action against the army personnel is concerned, the commander so-and-so has been warned for lapses on his part and lapses on the part of other officials. Other officers' personnel were not established prima facie. An additional court of inquiry was convened on so-and-so, wherein the army rule so-and-so has been invoked, and the petitioner, amongst other, is a part of the court of inquiry. He was a part of the court of inquiry. It is pertinent to mention here that the disciplinary proceedings after court of inquiry has to be proceeded under the CCS CCA rules 1965 and not under the Army Act 1950. The petitioner has full liberty to cross-examine the witnesses once the disciplinary proceeding progresses. Naturally, he will have the opportunity of cross-examining the witnesses. But the proceedings by itself cannot be stalled by way of an interim order.
My Lord permits, I'll cite the Supreme Court order where my Lord has inquired how the grave officers come under the jurisdiction of the Army Act, my Lord. This is para 14. This is a judgment of Supreme Court. Then Chief Justice Deepak Mishra, my Lord. delivered on the issue of border roads organizations. And another order I am submitting, my lord, this honorable coordinate bench order, and this is para 4.
Here.
Citation.
What?
SRO 329 mile and 330 mile. General Reserve Engineering Force, Grave, my lord. Those are the exception of the Army Act vis-a-vis Army rule, my lord. My lord, this Guwahati High Court bench order, my lord, this para 16 mile.
Come one by one. Allow us to go through your placing the judgment. Give us some
I bow
time to
down.
Go through it.
I bow down.
Citation to give.
Para 16.
Supreme Court judgment you have placed is only question of whether administrative tribunal or the armed forces tribunal will have.
But my lord, but for my lord's information of Army Rule SRO 329 and 3
That's all
that
right. Army-
highlighted,
Army
and
Act-
that is
Army
because I am
Act is-
subject to the Army Act, my lord.
So Army Act is applicable not only to the army personnel, but all personnel who are serving,
Subjected to that. Yes,
serving with the army.
yes.
Now, if that be the case, why have you not approached the armed forces tribunal?
My lord, that is when they try under CCCCA rule, this order has clarified, my lord.
Hmm.
If Justice Deepak Misra's order, my lord, if they try under CCCCA rule, then I have the liberty to come to this High Court, my lord. That is a settled issue. And if they try under the court marshalling, then I can go to the AFT.
Of course you can, but question is, what is your challenge?
My lord, I have your challenge.
If you are challenging the CCS rule, if you are challenging the CCS rule on the ground that these are not applicable to you, but armed forces, it's only the Army Act and the rules which are applicable to you. This is one ground.
No, my lord. I draw my lord's attention to some of the important facts they have submitted in their rejoinder, in their counter, my lord.
What is the basis of your
Basis, yes, my lord. My basis is, lord, my lord. In civil department, what happens, my lord? They hold the preliminary investigation. In the Army Central Department, where the Army Act is involved, my lord, rather than holding the preliminary investigation, they hold the court of inquiry with reference to, my lord, Army Rule 177, which is spelled out. And the moment one Army court of inquiry is convened, my lord, then definitely Army Rule 180 to be invoked.
Yes.
And because there is a lot of judgments of the Honorable Supreme Court also about in this matter of Army Rule 180, my lord.
180.
Yes, 180.
One 180 is only in respect where your character or military reputation is affected.
Yes, my lord. My lord, I have submitted one Supreme Court judgment, my lord. Para 53, my lord. Sanjay Jethani, Union of India versus Sanjay Jethani. There are many number of judgments, my lord, which I have spelled out in my convenience note, my lord. I have just now submitted. Para 53, I draw my lord attention.
'53.
Yes, my lord.
Yes.
I read, my lord. In a court of inquiry, participation of delinquent officer whose character or military reputation is likely to be affected is a categorical imperative. The participant has to be meaningful, effective, and he has to be afforded adequate opportunity.
What is the meaning of character or military reputation?
My lord, character means there is a because, my lord, if my lord go to have a look of their counter,
Any Supreme Court judgment on this?
it is a Supreme Court judgment.
No, character and military reputation.
Yes, my lord, they have gone further, my lord. In this matter 53, they have gone further, my lord, and it says, my lord, this in character and military reputation, then this says it needs no special emphasis to tell that Army Rule is Army Rule 180 is framed under the Army Act and it is the statutory color and flavor.
No.
It has the binding effect on court of inquiry, my lord.
Correct.
The rule provides for procedural safeguard regard being had to the fact that a person whose character and military reputation is likely to be affected is in a position to offer his explanation and in the ultimate eventuate may not be required to face disciplinary action, my lord. if I am given an opportunity,
Oh, see, as far as you are concerned, there is no question of affecting military reputation because you're not a military person.
I'm a military, I'm a military person, my lord.
You are,
I am subject to the Army Act. I am putting on uniform.
you're putting army uniform.
I am commanded by Lieutenant General.
Now,
It is a blot on my face, my lord.
what is the definition of a military reputation?
Military reputation means, because if they castigate on aspersion on my character unwarrantedly,
What you are submitting is that if you are an army personnel,
yes, my
there's
lord,
no question of proceedings under CCS.
I'm in the major rank, my lord.
So there is no question of CCS rules.
No, my lord. So what happened in the grave, there is a dual rule is applicable, my lord. I bow down and submit. One day, it is up to the disciplinary authority to decide. My disciplinary authority is the Ministry of Defense, my lord. It's a hybrid organization. It is commanded by Lieutenant General, my lord. And in the project, my lord, see the project Bhartak. It is commanded by the Brigadier, my lord. And again, in the project, there is a downward, there is a task force. It is as good as regiment in the Indian Army. It is commanded by Colonel. Vis-a-vis grave officer in the rank of superintendent engineer. My lord, I beg to submit, my lord, based on the manning ratio, army personnel are deputed. So that is why, my lord, to maintain the discipline of the entire force, since I belong to the Generalism Engineering Force, putting on uniform, the Army Act has been involved.
Right. So if the Army Act is involved,
Yes, my lord.
is it your case that instead of applying the Army Act, you have been forced to the proceedings are initiated under CCS rule?
My lord, what happens, my lord? If my lord have a loop of their counter, my lord, I just one.
We are trying to understand.
Yes, my lord.
basic-
My lord,
basic
this
purpose
because
which you are urging before the court.
I bow down, my lord. I submit. Based on the recommendation of the Court of Inquiry, my lord, which is biased, vitiated, and uncertain, they have proceeded against me, issuing me the memorandum. It is the commitment in the page number 63 of the counter affidavit by Union of India. Yes, they have proceeded based on the recommendation of the Court of Inquiry, my lord. Firstly. Secondly, they are categorically committing in page 76 of the counter that yes, you have not got an opportunity to cross-examine during the course of Court of Inquiry. Now you bring Captain Vishal Mohan as your defense witness during the general inquiry. So it is their own admission, oblique confession, that because of their memorandum originated from the recommendation of the Court of Inquiry. So my humble submission that recommendation is biased. First recommendation was given in April 22. Second recommendation has been given in July 24. Court of Inquiry convened in August
Will you show
20.
us any authority that if the recommendation is not as per the rules, no proceedings are contemplated? One can understand that if the Court of Inquiry proceedings are not as per.
Yes,
the
my
Act
lord.
and the rules.
Then I'll draw my lord's attention to the convening order, my lord.
Yes.
Yes.
No. We want to know, you see, it is not your case from the submissions which you have made, subject to correction.
Yes, my lord.
It is not your case that instead of sending you for further inquiry under the army rules, they have opted for CCS rules. You are not agreed by that. You are agreed by the fact that this inquiry under CCS rule is pursuant to a recommendation under the Court of Inquiry. And the Court of Inquiry, according to you, is not as per the rules and proceedings. That's your case.
And second, my lord,
Now,
another case, my lord, my memorandum is vitiated because of uncertainties, conjectures, and so on. And that Supreme Court has decided a government of AP.
that is on a different.
Yes, my lord, there are two issues, my lord. There are two issues.
If you challenge the memorandum,
Challenge the memorandum.
you challenge the memorandum means you have accepted the jurisdiction of the CCS rules. You are
Yes, my lord.
agreeable, you are agreeable to a proceedings under CCS rules.
I've challenged the memorandum. Yes.
Challenge them.
Yes, my lord.
Now, show us any authority to say that prior to holding a CCS rules, the procedure mandated for court of inquiry, etc., whatever procedure is there,
Yes.
is
Yes.
required to be
Yes, my lord. Yes, my lord. I bow down, my lord.
religiously followed.
Yes, my lord. My lord.
Had it been a case of recommendation towards court martial, supposing this court of inquiry proceeds, makes an inquiry, recommends that you should be court martial. We are with you that the procedure prescribed under 170, 177 rules are to be followed. Here is a case where the recommendation is for an inquiry. Purpose of the inquiry is to find out the truth in the allegations against.
I bow down, my lord. They could have proceeded, they could have held a preliminary investigation. They could have held a one-man inquiry rather than a formally convening a court of inquiry.
No, how does it affect you? As yet, no adverse order is passed.
My lord, in the court of inquiry, I have been denied the opportunity to cross-examine the vital witnesses, my lord.
That can be taken care of in the proceedings which you are now putting to challenge. If you submit to the proceeding, you'll get all opportunities, filing WS, examination of documents, examination of your witnesses, all opportunities will be.
My lord, that because what?
And
Because
for
on
all we
fee
know-
issue, yes, my lord.
know, at the end, they may say that the charges are not true.
My lord, that
They
is
may say-
my lord. Then even if that intervention of this constitutional court in the matter of the quantum of punishment is very limited, my lord. I bow down, my lord.
No.
So that's why I have come back to that, so that it is not escalated.
No.
Why it is escalated, my lord?
But to challenge a proceeding, you must show that these proceedings are not maintainable in the first place.
Yes, my
Or
lord.
sort.
Then, my lord, I beg to draw my lord's attention to the counter.
Yes.
It is not my admission, my lord. It is their admission. Page 63 for a moment, my lord.
Yes. 63
Page 63 of the counter affidavit file, my lord.
in which writ petition? Second what?
Item number 31, my lord. 4861 writ petition, my lord.
Or it. Page number?
63, my lord.
63.
Roman 3.
Yes.
I read, my lord. Keeping in view of the discrepancy brought out in the vigilance check, court of inquiry was ordered.
Yes.
Abide headquarter letter dated 24/11/20 and convening order dated 12/7/22. So, my lord, the first court of inquiry held in 20 and then reconvened in 22. So, my lord may inquire why there is a necessity of reconvening the court of inquiry, whether there is an lapse, defects, whether non-compliance of 180, etc. That my lord may inquire. To find out the exact fact, lapses, irregularity, and identify the officials.
In the first writ petition, you are challenging the court of inquiry.
My lord, in both the cases, the challenge is same.
Then
In the both writ petition.
why are you filing two writ petitions?
My lord,
One
that
case
is
came later on.
that is
One
joined
case
later.
came later on.
Who came?
One client came to him later on.
Second-
separate person. There are two separate petitions.
Two writ petition, yes. So I am talking about the writ petition. I am reading from writ petition 4861, wherein the first was granted on 20th November 24, followed by Itanagar bench order 4th April 25. My lord, this I read, my lord, page 63. To find out the exact facts, lapses, irregularity, and identify the official responsible for the same. Top, my lord. Involvement of official, including petitioner, prima facie, established in the court of preliminary inquiry. Now, court of inquiry, oblique preliminary inquiry. It is not a preliminary inquiry. They are misguiding, my lord. Then, and final recommendation order for initiating disciplinary proceeding under Rule 14. This is very important, my lord. My lord, may note it.
Rule 14 of CCS.
CCS rule, my lord.
It's
But major penalty has been spelled out, my lord. So it is their own admission, my lord.
Yes.
It is their own admission, my lord. Involvement of officials, including petitioner or prima facie, established in the crown, prima facie established in the court of inquiry. Malab, they are halfway gone, my lord. It is they have already decided their mind, and if the contents of the memorandum, if my lord have a look, it is already, it is not an alleged to have committed. It is they have committed, my lord. They have already decided preconceived mind, my lord. So there is a challenge to the memorandum also is referring to Supreme Court judgment. So, my lord, then I read following, my lord, and final recommendation order for initiating disciplinary proceeding under Rule 14 against 12 officers of 55 RCC, including both the petitioner under Rule 16 and one officer 81 RCC. Then, my lord, I again I draw my lord's attention to page 70 now.
Yes. Page number.
My lord, para 10, my lord. Page 71, my lord. I apologize, my lord. Page 71, para 10, my lord.
Yeah. Yeah.
Achha, my lord, in 70 also, it is very important also. I read, my lord, I'm sorry for the inconvenience, my lord. It states, my lord, the recommendation for initiating disciplinary proceedings in para 9 down below, my lord, have been issued only after following due procedure as per outcome of vigilance check carried out and department and outcome of court of inquiry, my lord. Para 9 down below. They are committing that yes, because of the recommendation of the court of inquiry, the decision has been taken to initiate to comply with the Rule 14 and initiate disciplinary action. Now I draw my lord's attention to page 71, my lord. Para 10.
Yeah.
I read in between, my lord. As far as disciplinary action against the army officer person mentioned in the para is concerned, the Commander 7662 has been warned for the lapses on his part. Who is the commander, my lord? My senior, my lord. I am working under him. He is responsible for the recruitment of casual paid laborer vis-a-vis payment of the casual laborers in consultation with the audit authority. My lord, he has been warned on the other officer who are not established, on the part of the other officer, person who are not established prima facie. My lord, meaning thereby, my lord, every time the Union of India is saying that yes, the genesis of the all actions, subsequent actions arises from the recommendation of court of inquiry. Because lapses of the commander who is heading the unit is so minimal that he has been warned. My lord, it attacks the law of equity. Because for the same offense, they cannot have a different punishment. He should have conducted.
What is the punishment?
My lord, he should have been tried by the court martial. Why warning?
That's a different issue.
Okay, my lord. Now I am not on that issue, my lord. And now page 76. Yes, my lord. I bow down, my lord. Page 76. I am leaving it, my lord. They have warned my commander. I leave it to my lord's discretion. Page 76, my lord.
Yes.
Page 76, my lord. Roman 10, my lord. I read, my lord.
Yes.
The statement of petitioner is misleading. The disciplinary proceeding against the petitioner initiated under CCCC Rule 1965, my lord. The petitioner have full opportunity to examine second in command, 2IC, and in charge E2 section of 55 RCC during disciplinary proceeding. So they say that yes, you will have an opportunity to examine the second in command, who was left out for the examination and cross-examination during the court. Then I submit, my lord, just 2 minutes, my lord. And C. B. Kishan was officer command and his cross-examination court of proceedings immediately does not arise. As far as the Captain Vishal, my lord, who is the medical author, my lord, the facts of the case is that the names and father names of 18 casual paid laborer match with the names and father names of.
We are not sitting here as a disciplinary authority or.
Yes, my lord. My lord, then they say what they are committing, my lord. As far as the Captain Vishal AMC headquarters 76 to BRTF, he has the medical officer who checked the casual paid laborers at the time of recruitment, my lord. Is concerned, he may be included as defense witness. Why? How I can captain who medically checked the casual paid laborers of 18 casual paid laborers and who has been left out from examination and cross-examination, including punishment, because with the recommendation of second court of inquiry, in the first recommendation, he has been penalized. And the DG just turned around. DG made a second recommendation after 2 years.
Therefore, we asked you 2 questions. That number 1, if you submit to the CCS rule, then you can question the tenor of the show cause notice, that charges are not specific, or these delegations or documents are not being allowed to be examined, etc. The other is that no, you're an army personnel, CCS rule doesn't apply to you. It should have been under the Army Act and rule. This is not your case.
My lord, they preferred not to try me under GCM. They could have.
The third is that you are holding some authority to say that once you hold the court of inquiry, there's no question of CCS, you proceed under the Army.
No, no, that is not my case.
That's right.
My lord, why I beg to submit, my lord?
Right. The court of inquiry will have to be treated to be some kind of a preliminary inquiry, on the basis of which they have decided that.
My lord, this honorable court also have submitted one judgment of this coordinate bench also, my lord. They have this bench also in the last paragraph, that is of Naresh Kumar Upadhyay versus Union of India, my lord. In the paragraph 16, my lord, this honorable bench also decided, yes, since your court of inquiry is vitiated, further consequential action. My lord, I don't have any objection, my lord. If they hold, after 4 years, they have given the recommendation exonerating.
We'll examine all that. We are only concerned that there is an interim order staying the further proceedings. Now, whether these allegations are correct, incorrect, is for the authority.
But it can be kept from hearing, my lord, if my lord is pleased and parted matter.
Parted. Why parted? We only want to know that you are praying for setting aside of the proceeding itself.
My lord, yes, my lord, my lord, yes, my prayer.
Memorandum of charge.
My lord, yes, I draw my lord attention to my prayer, my lord.
What do you say with regard to the judgment of the coordinate bench?
Lordship, if your lordship will, my friend has given me a copy. It's Naresh Upadhyay.
Para 16, my lord.
If your lordship will come to the penultimate paragraph, Naresh Upadhyay is a case wherein penalty was already imposed. Now we are still in the stage of inquiry. He can take all those pleas in the disciplinary proceeding. If there is something wrong, he can always take that plea. Now he has submitted his reply, and after that he comes and says, no, the memorandum of charge is not proper. How can that be, lordship? It is already initiated, and he has submitted himself. Okay. And lordship will come to paragraph 15. Here there was some recovery made even before the initiation of the DP on the basis of the court of
No,
inquiry.
you go through the judgment if you have not gone through and tell us.
No, I have seen that lordship. Lordship will see paragraph 15, 16.
Hmm.
As a matter of fact, the penalty of recovery of rupees so and so had been imposed upon the writ petitioner even before initiation of the departmental proceeding to establish such a charge. In the instant case, lordship, no penalty.
Penalty imposed by whom? By the army authority.
By the BRO authorities, lordship. This is
BRO.
also a case of the BRO. So,
It is not under CCS Act, my lord, recovery.
no, it's all right.
It is not under CCS, no provision.
Lordship
is
is not getting the point. Lordship, here
That's
was
the
a case
recovery.
where there.
It is based on the recommendation of court of inquiry, again, my lord. If my
we
lord,
are not on
Has
that.
any recovery been directed against you?
my lord, my case is in, I have a, my lord, I bow down and submit, my lord. As a preventive maintenance, preventive check, as a OC unit, when I found the names and father names of 18 casual paid laborers are matching with the names and father names of another 18 the laborers of some other detachment, 8 detachment, which are located 150 kilometers away from each other in Kargil sector, I had the MS Excel and told ICICI Bank official not to release the payment till their re-verification is done. That is my case, my lord. This is the case. This is the preventive check I initiated. That is my fault. Otherwise, my brigadier chief engineer, my army commander who would not have been exonerated, army doctor who examined the 18 CPS, who should have been called in the court of inquiry for a deposition, some other relevant officer, they should have been called for the deposition. They dragged on the case from August 20, 2020, gave the first recommendation in April 22, gave the second recommendation in July 24, and last but not the least, my lord.
Mr. Counsel, please understand the
Yes,
case of the court before you make a submission. We are asking you repeatedly that it is not your case that you have to be proceeded against under the Army Act while they have proceeded under the CCS. This is not your case. You are not agreed by that. You are not agreed by the fact that the authorities after the court of inquiry, they have sought to impose a punishment or made any recovery.
No,
There is only a
my lord,
there is only a,
my lord, yes,
there is
I
only a
have challenged the
conclusion.
memorandum,
So
my lord.
kindly listen to the court. There is only a conclusion
Yes,
that there has to be a disciplinary proceeding initiated.
yes, madam. I bow down. My
Now,
lord,
your grievance is that you are not given an opportunity to cross-examine before the court of inquiry. Therefore, the conclusion is
no, my lord. In my convenience load, I have given the lot of citation of the Honorable Supreme Court. If the court of inquiry is vitiated, what is the consequential effect? So I do not want to submit anything about the court of inquiry. Now, lastly, my lord, my second challenge is my vitiation of the inquiry. And that's why, my lord, just a moment, my lord, 1 minute, my lord, para 10. Para 10 of my
we thought
para 10, just a moment, how I am aggrieved because of the vitiation of the memorandum.
See, a judge is not only supposed to listen, he can speak sometimes if you permit the court to speak.
Yes.
Right. So we have this IA. We thought we will tag the IA and go for a final hearing, but prima facie, I think we can dispose of the IA first. So therefore, we'll issue notice in the IA. If you want, you can file your objection in
Deeply obliged.
2 weeks' time.
Deeply obliged.
And I don't think prima facie that the stay needs to be enforced. You will get all your facilities to add the matter before the authorities.
My lord,
We are still giving you an opportunity to file.
yes, my lord. My lord, this, I have spelled out how I am aggrieved because of the vitiation memorandum in para 10 of my petition, my lord. My lord, it will be, as a law officer, my lord, I beg to submit, my lord, if my lord calls for the records, my lord.
We'll do when we. proceed
My
to
lord,
hearing.
just 4 things I beg to submit, my lord. What tempted Director General Border Roads to reverse his first recommendation, my lord? Because noting is very much, I have seen, my lord, I bow down, my lord, in the Supreme Court also, they call for the entire records because mind is best demonstrated whether there is a reasoning or not, my lord.
Correct.
So including noting, my lord, first recommendation.
Therefore, at the most, it has to be
I leave it to my,
it is
my lord. This-
preliminary inquiry. Let us say it is a preliminary inquiry unless you say that no under the act or the rules or any other guidelines, notification, the court of inquiry is mandatorily required to be held to decide whether proceedings are to be initiated against you. If you can show us some
My lord,
authority,
all the citations, that speaks for my case. That is only submission.
So we'll
And
issue-
para 10, how my charge sheet is
we'll issue
vitiated.
notice in your
My lord, this para page 9, para 10. My lord.
you prefer to file an objection, or if you want to file an objection to the IA, we can issue a notice.
Yes, my lord. Deeply obliged.
Right, Learned Counsel. Your name, please.
Tapas Das, my lord.
Tapos Das. Learned Counsel representing the petitioner in the pleadings are complete. So far as I is concerned, Mr. Architect of
I, Lordship, will record my
Mr.
presentation.
U.K. Goswami, he has filed his IA, paying for vacation of notification of the interim order dated 0/11/2024, passed at WPC 4861 of 2024. There are issue notice, returnable 3 weeks.
My lord, 21st August is convenient to my lord.
When
Next
21st
date.
August.
Not 14th of August, sir.
Let us have an early date because there is an interim order. You can join us online if you want.
If it can be on 28th, Lordship, it's a Monday.
Huh?
If it can be on 28th, 28,
28.
28
So,
July.
we have given him 3 weeks.
Oh, Lordship, I am sorry, Lordship. Then
Let it be on
for-
11th of August.
11th of August.
Returnable on 11th.
Yes.
I will take the importance. I don't know. Hopefully, party may file their objection. If any.
11th of August. Deeply
That
obliged, my
will
lord.
be listed on 11th of August. If passed, it will take place.
Deeply obliged.
Lordship, both the matters.
Both, all 3, including I.
Lordship.
Interim order to continue till
Yes.
that, my lord. In both the matters, my lord.
Yes.
There is no interim order in
We don't know
WPC
wherever it is
19.
there, it will continue.
There is no
They
interim.
say it is a club case. They say
Seems-
one order
there
is
an
interim, another is
There
not
is no
there.
interim order in
Wherever the.
I don't
WPC
argue, my lord. I am deeply obliged to my lord.
This side. Yeah. Instrument. It will be. But he is reading from his file. Yeah. If already would not read, you would try to tell that to the matter, it will go back. It takes matter to my.
May I please, Your Lordship? Your Lordship, on the last occasion, Your Lordship has raised a query as regards Your Lordship, as per the office memorandum, Your Lordship, 4th of February 2020, as to whether the quarterly returns required to be submitted by the department with the details of suspension orders, memos of charges or charge sheet, as well as the extension of the suspension period of the personal B department were served on delinquent officers or not, Your Lordship. Your
Where
Lordship.
is Mr. I. Thakur?
Yes, Your Lordship. He has asked me to pray before his honorable court that the matter may be taken up after some time, Your Lordship.
After some time.
Yes, much obliged, Your Lordship.
Yes, Mr. Soikia. There appears to be some error while listing your matter. The matter which is listed here, 378, which is shown here, is a bench 2 matter. Item number 2 in the cause list. Writ petition 378. 378, we have called for the file. This is the civil bench 2 matter. And the matter, the file which has been sent here is not shown to be listed. So this matter will have to be listed again. So no order, we can't pass an order. Court master will inform the registry, they will list the matter.
Yes. Obliged.
May it please, Your Lordship.
But then some judges.
Yes, Your Lordship.
Yes.
Most I'd like
That
to
much
ask,
only.
tender my sincere apology, Mr. Dusam is not present, Your Lordship. The judgment which I will provide, Your Lordship, I have gone through the judgment, those are not applicable in our matter, Your Lordship. If Your Lordship takes as the first Vikas Roy,
No,
judgment,
we
Your
pick
Lordship.
it up on some other day, no.
Lordship.
If Mr. Goswami wants to be
Your
present.
Lordship, I can place it, Lordship.
All right. So, let us have it on 29.
I'm not sure whether Your Lordship will be available on 29th or not, Your Lordship. Lordship, may I am not sure he'll be available on 29th.
No, we don't know. We are just saying. Tell us.
See, wait, finish up today, Your Lordship. I can submit only like 5 minutes, Your
You
Lordship.
may finish it today, but we'd like to hear the matter because we'd like some, we'd like you to refresh our memories.
You can try and.
You'll be present on 29th.
Yes, Your Lordship, 29th.
29th.
Much,
Obliged.
much
Lordship.
obliged, Your Lordship.
This matter also,
hard,
Lordship.
This will pass orders.
Yes.
Where is Mr. Borpujari?
My lord, he informed, my lord, he is in court number 17, he said.
Inform him that
Yes.
we are passing orders.
Ah.
Yes, sir.
Obliged. Lordship, instead of conducting advocate is are going in court number 23. After sometimes
It is the conducting counsel.
are Magan ground. For some time, my lord,
After.
not.
Yes. Why is GST here?
Lordship, it was listed before court number 8. My learned friend mentioned that it was heard by your lordship earlier.
Not part heard.
Not part heard.
The remained part had. But on the last occasion, when lordship asked me to submit the written submission, on the day that unfortunately my mother acquired, I could not present before you.
Was it part heard?
Earlier it was parted. 'Third. 'Before your bench.
Lordship, it was listed before court number 8. My learned friend mentioned that it was heard by your lordship earlier. Not part heard.
The remained part had. But on the last occasion, when lordship asked me to submit the written submission, on the day that unfortunately my mother acquired, I could not present before you.
Was it part heard?
They got hurt by your lordship.
Substantially hurt by your.
Because
Was it hard?
Yes.
I didn't make my submission
Huh?
till date.
How can it be hard?
Your lordship substantially hurt. 2-3 days continuously. Issue regarding page 124, your lord.
One 24.
Yes.
What is your case here?
Yes, case here, your lordship. In nutshell, I am submitting a lordship. Earlier, there are two notices 3299 and 3399 for 10 years, 100% exemption.
Hmm.
Subsequently, in 2007, another notification to 20/2007 has been issued, and that was also giving 100% exemption. Subsequently, 2008, notification 17/2008, 18/2008, 27/2008, and 31/2008, 10/6/2008. This three notification has been issued, whereby Government of India reduced the restricted the exemption limit to the extent of 36%, 40%, 25%, 36%, and to the extent of value addition, and fix the rate of percentage. So the certain unit, those who are enjoying 100% exemption, aggrieve.
Just what?
Certain unit, those are enjoying 100% exemption, aggrieve and file a writ petition before the court, challenging the notification 17/2008, 18/2008, and notification 31/2008, 10/6/2008. This Honorable High Court, single judge, your lordship, has allowed the writ petition, held that the notification is not sustainable and they should be set aside and quashed. Subsequent to the single judge judgment, revenue went on appeal before the division bench. Division bench in its judgment did not interfere with this appeal and sustained the single judgment judgment. Thereafter, contempt of court proceeding has been initiated before this court. In the meantime,
We'll come back in 2 minutes.
yes, by the aggrieved parties. And in the meantime, similar matter of case from Gujarat, VVF Limited versus Union came before the Supreme Court. While VVF Limited came pending before the Supreme Court, Commissioner of Central State Guwahati has filed an IA, 3/2015. In IA, the Honorable Supreme Court passed an interim direction that, subject to condition, 50% amount to be paid back, refunded to the out of the due amount to the unit petitioners, and in the contempt proceeding will be stayed. And accordingly, that 50% has been refunded to us. Finally, the Honorable Supreme Court decided the VVF Limited against the unit in favor of Union of India and held that the notification, three notifications, 17/2008, 18/2008, and 31/2000 is mere clarification nature. High Court has committed mistake. So this has been set aside. So in view of VVF Limited, when gone for the in favor of the Union of India, VVF Limited says judgment will be retrospective, not retroactive. But whatever action has been taken, that will not be acted. But its judgment will be retrospective effect. And there is no indication at all whether that 50% amount will be refundable or not to the department. In view of the death judgment, taking the clue from the VVF Limited judgment, paragraph 15 and 16, department issued notice. The department raised demand without issuing so cause notice, holding that
whatever the amount refunded to you, it is held to be an erroneous under section 11A. Our question is that in my case, the notice shall have to be issued, a so-called notice, which is a precondition for recovery measure under section 11A of the Act. And without issuing the notice, no recovery can be made. Secondly, it cannot be erroneous because at that relevant point of time, law was in force. It is as per the direction of the Honorable Supreme Court, law is there, so it cannot be held erroneous. Your Lordship, kindly see the single bench judgment. I am producing first before your Lordship. This is single bench judgment, your Lordship.
What is the name?
It is a Harbor Foundation versus others, 2728, paragraph 157, 158. Paragraph 157 and 158. Loss of party portion, your
These
Lordship.
are all after, prior to VVF.
Yes, VBF. After VBF, no judgment has been delivered. In my case, is there. So, VBF limited, your Lordship will find page. Paragraph 97, your Lordship.
What about this Topson cement?
Topsom cement, your Lordship, is with me. Topsom cement is in my favor, my Lordship. Says that it cannot be held to be an erroneous because law was in force.
What has happened to Topson? Appeal?
Yes,
Any appeal?
yes, yes. It is 2021, 2 GLT 755.
Any appeals filed against the judge?
54, your Lordship, is paragraph 54. It is clearly held that. As such, I am perusing your Lordship. I do have copy for your Lordship. Lordship, kindly take my compilation. Your Lordship will find paragraph 54, top same page 35. To some extent, the old paragraph 50. I'm reading your Lordship. Paragraph 54. If your Lordship permit. As such, on a perusal of the law discussed above, it can be held that the concerned department officer exercising power under section 11A of the Central Exercise must arrive at a finding that earlier order refunds as have been granted in the present proceeding were contrary to the law and therefore correctness and the same are required to be reopened or recovered by invoking powers under section 11A. Refunds were granted by the department terms of the judgment as SRD Nutrients Private Limited. As discussed above, the department accepted the judgment of the apex court SRD Nutrients Private Limited, sanctioned the refund as such. The contention of the department that the refund granted earlier were erroneous and could not be recovered under section cannot be accepted. The ground argued by department supporting impugned so-called notice do not satisfy the requirements of 11A. Division bench of this court in Rajendra Singh Supra, Victor Camp Industries, the binding precedent. As such, I respectfully concur with the same. Therefore, refund granted under cannot be considered erroneous to invoke the power of section 11A of the Central Exercise Act only on the premises the judgment of the apex court unlimited was held to be par inferior by the apex court supplemental uniform justification. So this is similarly in my case, my lord. In my case, they have not issued notice under section 11A. They have made a demand notice, as your lordship will find. Page 124.
This the Kesaria industry,
Lordship.
along with this, some other repeats were also there.
Yes, Lordship. In this case, Lordship, that Topsam Cement, the issue was different. In that case, Lordship, on the basis of Supreme Court judgment, department refunded the education cess and higher education cess.
In that SRD.
Yes, thereafter the judgment was held to be per inquiry. Then department issue notice that department should be given opportunity to recover the amount. Then single bench Lordship has held that no, it cannot be recovered. Then we went to division which dismiss our case. Then matter came to Supreme Court. Once Jammu has case judgment went to Supreme Court. Supreme Court held that it cannot be, once matter has been settled, it cannot be reviewed subsequently. But here, Lordship, the issue is entirely different. Lordship. Here, what happened, Lordship, when the rate appeal SLP was pending, then different rate petition were filed before this honorable court, and contempt petition was also filed. Then, Lordship, page 115 of this petition, Lordship. Page 115.
Yes.
May I read, Lordship? This is a small order.
Yes.
But pending further orders, we direct that the subject to the petitioners releasing 50% of the amount due to the respondent in terms of the impugned judgment of the respondent, furnishing solvent surety to the satisfaction of the jurisdictional commissioner. The operation of the impugned judgment shall remain state. We further direct that the contempt proceeding initiated against the petitioner shall subject to their releasing 50% of the amount as stated remain state. Yeah, Lordship, thereafter.
So 50% was released.
Yes, and Lordship was subject to the condition of satisfaction of the judicial commissioner. Then Lordship, they executed a power of attorney in favor of the department. That is at page 148. Then they issued solvent surety in favor of the department. Thereafter, Lordship, behavior judgment come. The notification was held to be upheld by the Honorable Supreme Court. Lordship, when they have been given solvent surety, it is their bounden duty to refund that amount. Even the notice is not necessary. They said that the notice is to be mandatory. Lordship, may please to see the notice.
No, but what about the view held by this court, which is being also upheld by a reason bench, that once there is a dispute inter-party, which has been attained finally, merely because at that point in time the law was SRD nutrient.
Yes, Lordship. But the issue was entirely different in that cases and in this case, Lordship. Here we refund the 50% on the basis of Supreme Court's interim order. Then the final order was passed, upholding the allowing the SLP, Lordship. And as per the direction of the Supreme Court, they executed solvent surety in favor of the department. Lordship, I am relying on one judgment of Honorable Supreme Court. This is similarly the same issue. Paragraph 3, 4, 5, and 6. I'm reading paragraph 3. The learned counsel for the SEC drew our attention to the notice requiring SEC to make repayment of the amount refunded. The notice was issued under section 11, and in the learned counsel submits the submission was made out of time. We asked learned counsel whether the reversal by this court of the tribunal's order on classification would not by itself require SSCs to make restitution of the sum that the revenue had refunded to the 8% to the tribunal's order. Learned counsel fairly stated that such restitution was requisite. Plainly, the SSC is obliged to make restitution. The revenue honored the tribunal's order and made the refund. Upon reversal of the courts of the tribunal's order, the SSC was bound in law to restitute the amount of such refund to the revenue. The approach of the tribunal, we must say, was quite misconceived, more so in the light of the undertaking which the SSC has given. The civil appeals are allowed. The SSC shall pay to the revenue the amount refunded to it pursuant to the order of the tribunal within 12 weeks with interest thereon at the rate of so and so. But see the same issue here, the amount was refunded on the basis of Supreme Court judgment. And Lordship, and they executed solvency in favor of the department.
Account was funded because the Supreme Court had granted a stay.
Yes,
Uh,
subject to payment of 50%.
You did not file contempt petition.
We are not passing contemplation.
But on the basis of this order, Lordship, the 50% was refunded to them. And they executed solvency in favor of the department also. When the SLP was allowed, it is their bounden duty to refund the amount. Even the notice is not necessary. But we issue notice to them to refund the amount. Now they say that section 11 will be applicable.
No, they have not issued a notice to us, my lord.
Yes, yes, it is.
No, notice. It is direct demand notice, my lord. By page 124. Not section 11. and
Not required, Lordship. Where they've executed, Lordship, may please to see their solvency routine, Lordship. Page 124, 148.
$149.
Start from page 148. Page 150, Lordship, last two paragraphs. The bound that they will refund the amount when the order will be passed in favor of the department. And the issue in top same, Lordship, in that case, that was an entirely different issue.
You are given an undertaking, you will return.
No, it is not undertaking. It is solvency routine. My argument is that, your lordship. It is not. It is that my company is financially sound capability.
No.
They is solvent, but I am not giving undertaking. Undertaking.
You see 150, page number 150,
Yes,
last
yes.
paragraph,
Your lordship.
last few lines, last 3 lines.
Yes, lordship. Rule, act and rules demand or any authority appointed by government under the Central Excise Act and rules such demand to be written to be served upon the above bounded and their harass excuses legally represented of any other person acting on behalf of the order, terms of manner and within the period provided by prescribed under the said act and rules made thereunder and shall also all times indemnify the save the government from the all loss, cost, expenses have been sale or may at any time thereafter during the period in which the above burden is held pay any such under the said act and cause the reason of the person acting or their them obligation shall be void and do otherwise the same shall be paid remain in full force with the prohibited under agreed event in the event of such petition upon control under the cessation of the liability under the act or rules thereunder. That means act and rules they are under Central Excise Act. So section 11A will notice will come. They have not issued notice. They have to act under the act.
They will issue notice if required.
They will issue notice.
Yeah.
Let them issue notice. Proceed like that.
That's a mere formality.
Formality. That they have to carry it out.
What about the EBF judgment? Is it here?
VBA page, your lordship will find it is page 97 is operative percentage of page paragraph 15 and 16.
97.
97.
97 is the operative part.
And view of paragraph 15, your lordship. In view of the above, and for the reason stated above, once it is held that subsequent notification industrial policies which are impugned before the respective high courts are clear between nature and are issued in public interest and in the interest of revenue, and they seek to achieve the original object and purpose of giving incentive exemption while inviting the persons to make investment or establishment of new undertaking, and they do not take any vested right conferred under the earlier notification industrial policies and therefore cannot be said to be hit by doctrine of promissory same is to be applied retrospectively and they cannot be said to be irrational arbitrary. Under circumstances, respective high courts committed a grave error in quashing the setting aside the subsequent notification industrial policies impugned before the respective high court on the ground that They are hit by doctrine of promissory estoppel, and they were retrospective and not retroactive. Consequently, all these appeals are allowed. The impugned judgment order passed by respective high court, which are impugned in the present appeal, quashing and setting aside the subsequent notification industrial policies impugned in the respective petition before the respective high court are hereby quashed or set aside. Consequently, the original writ petition filed by the respective original writ petitioner before the respective high court challenging the respective subsequent notification industrial policies stand dismissed, and for reasons stated hereinbefore, the challenge in the respective subsequent notification industrial policies impugned before the respective cycle fail. However, it is clarified that present judgment shall not affect the amount of excise duty already refunded, meaning thereby the cases in which the excise duty is already refunded prior to the subsequent notification industrial policies impugned before the respective high court, they are not to be reopened. However, it is further clarified that pending refund applications shall be decided as per the subsequent notification industrial policies which were impugned before the respective high courts, and they shall be decided according to the law and on merits as per the subsequent notification industrial policies impugned before the respective high court. All each appeal are stand disposed accordingly. No. But judgment never speak regarding the refunding.
Your refund was not given prior to subsequent notice.
Prior circular.
So you
After notification.
After.
fall under that. What about the second part?
There is a pending refund.
Refund
We do not have pending refunds.
which are to be decided in accordance with law.
No.
on
That
merit.
50, we have about from 2017 up to 2007 they have paid. They have not paid 50%. Out of the due amount, we have paid 50%. We have claimed more than that.
So up to 2017, you have received.
Yeah, no, not my lord. The prior your lordship, here is a paragraph calculation is here, your lordship. Page your lordship will find page 120 onwards, 119 onwards,
119.
119 onwards.
Oh,
Table
oh.
table A, B, C, D. They have calculated
No, 119 of what?
of my writ petition
Page number.
page number.
Yes.
We have worked theory. The details of refund claim sanctioned for the period August 2011 to 2017 as follows. Out of that, they have calculated 50% to the extent of 1 crore 10 lakhs. They have only taken 50%. 17, 18, 19, 20, there is nothing is not there. And they have sanctioned that paragraph number 12, 123, it would be appear from the table G above, the SSC claimant is entitled to the one so and so, being the 50% of the amount shown in column 6 of C. That is C column PLS so and so, August 2011 to March 2017. And remaining part is with their
Come again, you have received up to which period?
2011 to 2017.
You have received.
Yes,
That is
50%.
50%. That is up to table F.
Yes.
Then
Then there remains remaining part is with them 50%. Table C, column C, they have calculated 5 crore something else. There is 365, 441 crore something else. Table G, they have said financial year up to March 17.
so going by DDF, you are to decide on merit.
Lordship, it is decided. Lordship, probably my learned friend has not placed the correct fact. Lordship, may come to page 124.
124.
Order. I sanction rupees 1 crore 10 lakhs and odds only in compliance with the interim order dated 7/12/2025.
124.
No, not,
124. It's a
no, it is 129, your lordship. 129.
move to 124.
एक को दिला
159.
lordship fine. Order.
Part of the order, Lord.
This is pursuant to the interim order.
Yes, Lordship. Then Lordship, thereafter, I come to page 125. maybe. The order date, demand come recovery notice.
Page number.
Page in my application, it is 125.
Demand come recovery notice.
27.
EE.
What is the date?
It is 2/7/2021.
Page 124.
124, yeah.
124. This is demand notice for the married Lordship. The Honorable Supreme Court of India passed interim order on 7/12/2020 to 2015 in IN number so and so, filed by Union of India in SLP number so and so, in view of the in the case of Union of India versus Kamakhya Cosmetic Private Limited, which was tagged with the already pending cases similar issues, namely VVF and others.
Pursuant to this demand notice, any order is passed.
No, Lordship, because they approached this honorable court and case is pending since 2021, Lordship, it is pending, no notice was issued till date.
Now, according to you, this, you are challenging this demand notice, why? Because
I'm challenging, they state were trying to recover me and they will attach my bank account, they will attach the amount from the bank.
now what should be the procedure according to you?
According to procedure section 11(1)(a), because your lordship will find last paragraph 7 of the notice. They said that in view of the so and so, paragraph 7, therefore in light of the judgment of the Supreme Court upholding validity of the amendment notification discussed para above. I'm reading your lordship. There validity of amendment notification discussed in paras above, interim order passed by the Honorable Supreme Court IA 3 of the 2015 lost its relevance. Accordingly, amount 1,10,19,630 only sanctioned to you on the basis of interim order of Honorable Supreme Court and Guwahati High Court, representing 50% of the unpaid amount apart from the eligible amount. Sanction in accordance with the aforesaid notification 3299 dated 8/7/9 as amended, notification 3399 8/7/9 as amended, and notification 20 of 2007 dated 25/4/2007 as amended has been rendered erroneous, and same is liable to be recovered from you in terms of section 11A of the Central Excise Act 94, along with the applicable interest under section 11A of the said act, read with section 174(2) of the GS. So, if any amount was to be recovered under section 11A, a prior notice is mandatory. A1. And for that purpose, I have given some judgment, your lordship. I have some authority regarding that.
And this demand is issued under which provision?
Lordship, it is not, in my humble submission, notice is not required. When the amount was paid to them on the basis of Supreme Court judgment, once the judgment is reversed, it is their bounden duty to refund the amount.
You come back to the bond.
Yes, Lordship. Page 148.
Okay. You see, unless you show this as a provision under any provision of the Act,
Which one, Lordship?
Unless you show that this recovery is permissible without issuing any notice under provision of the Central Excise Act, you'll have to recover it as an area of land revenue.
No, Lordship, here that is not required because the amount was refunded to them on the basis of Supreme Court order, Lordship.
That's right, but you're still issuing a demand.
No, Lordship, that is because
Why
they,
issued a demand?
no, that was a mistake on the part of the department, Lordship. But Lordship, when the amount was refunded to them as per the Honorable Supreme Court's order, and they have executed solvent surety in favor of the department, that once the judgment,
You are a department. You are a part of the government.
yes, Lordship.
You are bound by the set of act, rules, implications, etc. Now, when you want to recover a money, there has to be a procedure prescribed. Even if it is pursuant to a bond, you must trace your powers, force of the powers, to some provision of the act or the rule. If there is no such provision, then you will have to recover it as an area of land revenue,
No, Lordship,
which is already specified here.
in my humble opinion, that is also not required in the present case. Since the amount was refunded to them, we were returned to on the basis of it interim order passed by the Honorable Supreme Court. When the SLP was decided in
You file an application before the apex court to say that in view of this vacation, there should be direction.
no, Lordship, may please to see page 129. Again, I
There is a direction that they should refund.
Lordship, may please to see.
129.
No, and not 129, Lordship. Please, interim order passed by the Honorable Supreme Court. This page 115, 115. I'm reading again the first paragraph. Pending further orders, we directed the subject to the petitioners releasing 50% of the amount due to the respondent in terms of the impugned judgment on the respondents furnishing solvent surety to the satisfaction of the jurisdictional commissioner. The operation of the impugned judgment shall remain strict. We further directed the contempt proceeding initiated against the petitioner shall subject to their releasing 50% amount stated above. Lordship, thereafter they executed solvent surety in favor of the department. The Lordship has seen the next page, Annex D, is the order. Last page of the that order after the Supreme Court's interim order. I sanction rupees 1 crore 10 lakhs and odds only it in compliance with the interim order dated so and so of the Honorable Supreme Court passed in IN number so and so for specially petition number so and so arising out of impugned and final judgment order dated so and so in writ of pin number so and so passed by the High Court of Guwahati in case of Union of India versus Kamakhya pharmaceutical so and so read with Honorable High Court's order dated so and so. The amount of refund sanctioned herein above shall however be subject to the final decision of the Honorable Supreme Court of India in SLV number so and so.
Now you show us in the final judgment of this DVM. What is the judgment?
Page 9, operative
Maybe-
post.
Page 97.
Operative post.
Is there any direction that the amounts which are
No, nothing is there.
are to be
No,
refunded?
Lordship, the interim order was passed in this SLP. That was merged with this order.
Huh?
That order has been merged with the final order, Lordship. When the final notification has been upheld,
We are not on that.
Lordship.
We are not. We are accepting your submission that the amount will have to be refunded.
Yes, Lord.
Manner of recovery. You have
Lordship,
to.
in this
show us.
case, Lordship, I am relying on one judgment of Supreme Court
You have.
in Dharampal Satyapal, where Supreme Court says that this is a mere formality, issue of notice.
Right, it's a mere formality.
And Lordship, that judgment of 2002, this clearly said it is a restoration of the order of the Honorable Supreme Court. Here it was the order passed by the tribunal. On the basis of tribunal's order, amount was refunded to them. When it was reversed by the apex court, then it was bounden duty of the SEC to refund that amount, restitute that amount. Lord.
No, but that is all right, but you see, you have released it on the basis of interim order.
Yes, interim order.
Now you see what is the final direction of the Supreme Court.
Supreme Court says that notification is upheld. It was set aside by the High Court.
That's all right, but the penultimate paragraph, the pending refund application shall be decided on merit.
Pending funder application shall be decided as per subsequent notice. Lordship, that why?
Lordship, here there is a note that we have already decided whether how much amount they are entitled to. But we are on the point when we refunded the 50% of the amount. They are challenging that only. Lordship. They said that it is should be under section 11A of Central Excise Act. And Lordship has seen the solvent surety. They bounded before the department that they will refund the amount as soon as the final order is passed by the Honorable Supreme Court. Regarding their determination, Lordship, whether they are entitled to 35%, 40%, that has not been put before challenge before this Honorable Court. Lordship. The demand notice which has been issued because that was issued in 2021 when they failed to refund the amount.
Yes, what do you say regarding restitution, the amount?
Restitution amount is not, that is the Dharampal Suttapal which has been produced by. Here the Dharampal Suttapal where section 154 subsection 1 RC Tobotu case is relied upon, where is expressly provided provision for refund, which has been relied by learned friend Dharampal Suttapal, where it is expressly provided that in view of the legislation made in section 154, which is expressly provided that should be refunded. But here the judgment not provided any indication that amount which have been already refunded shall have to be refunded by them.
So you have to urge, you have to refer to the provisions.
Provision section 11(1)(a). That is the only provision.
Mr. Counsel,
Yes.
you have to address, if you want to seriously address on this issue, that there is a provision for restitution of the amount which has already.
Well, there is a provision of restitution in the as per Central Excise Act.
There is no provision for restitution.
Restitution Central Excise is not there.
Where is the provision for refund of the 50% under Central Excise Act?
There is no provision.
Then you have accepted it.
Yes.
You have executed a bond. Where is the provision under Central Excise?
There is no bond.
Then
And even my lord, they have, if they want to recover it, they have to recover under. They himself issued the notice at section 11(a) of the Act. In terms of section 11(a), and hell it to erroneous. My first point, it cannot be erroneous. It cannot be erroneous refund.
all right, it is not erroneous,
Erroneous.
but it is under the orders of the court.
Orders of the court. So it is.
So you have received the amount under orders of the court.
Court.
You can't deny that.
Yes.
That was under the orders of the interim order.
Interim order.
Interim order passed by the apex court.
Apex court.
Subsequently, SLP dismissed.
Dismiss.
The interim order has to merge.
Have to be merged, but there are some indication. If
May not be, but that will mean that although you're not entitled to receive the 50%, you're holding on to this amount because there is no indication in the final judgment. Can this be an interpretation?
No, that cannot be interpreted.
Then
But
why are you making a submission?
another issue is there, but not retroactive. If I say this retroactive, retrospective word, retroactive, I means they will act. So whatever done, already done. That is not.
No, whatever done was done under the interim order, which was not final.
It should.
You'll have to say that if you want to argue on the restitution aspect.
No, I will not argue on that aspect. But my question only that, my only point that they have issued not, they have, when they have wanted to recover the amount, they have to issue the demand notice under section 11(a). They have to issue prior notice under section 11(a). And that also has been limitation 1 year or 2 years.
What provision are you making that statement? Under what?
Section 11(1)(a)(1).
11(a)(1)(a) is a recovery to be made when it is. You are referring to 11(a).
11(a)(1), where any duty of excise has not been levied or paid, or has been short levied or short paid, or erroneously refunded for any reason other than the reason of fraud, collusion, or any willful misstatement or suppression of fact or contravention of any provision of this act or rules that may are under with intent to evade payment of duty, the central excise officer shall within 2 years from the relevant date serve a notice on the person chargeable with the duty which has not been so levied or paid, or which has been short levied or short paid, or whom this refund has erroneously been made. As they said, it is erroneous refund be made, requiring him to show cause why he should not pay the amount specified in the notice. That within that period of 2 years. So the person chargeable duty is so and so. Again, wherein duty of excise,
What is your answer to this judgment? Uttra.
Uttar judgment, no, that is the undertaking. Uttar judgment I do have. Lordship.
Here also you have given an undertaking in the bond.
No. Bond is understood. They have written the certain words in the bond that it is solvent security, not undertaking.
Even you read the.
I have prepared my argument, Your Lordship. I have already seen the regarding that, Uttar Limited.
Where we are not on that. We are asking you is, where is your bond?
Page 149, Lords.
149. See 149. The last paragraph we pointed out, page 150. You have agreed that you will, on demand, you will release the amount. Repay. So they have made a demand.
In the bond itself, a demand by authority under Central Excise Act and Rule. Of the above bond, the bond shall remain with the appropriate authority recovering the sum that may be payable, bound and drop off so and so.
You have to come out of this judgment. Otherwise, either you'll have to argue that's no for restitution also. Provisions under the mandated under the act has to be followed.
Yes.
It's satisfiable.
Heard counsel for the parties.
2002 10 is
There was
2002. 2002.
2002 10 is
And page
page SSC 734.
734. Yes,
earlier date, subsequently. Still, again. For further hearing on Tuesday,
Much.
coming Tuesday. It's 22nd. 22nd.
Yes.
July. Matter be treated in part.
Much.
Is it only available? 7 people maybe? So not about people.
May I please, Your Lordship?
In this case, with regard to insult of his wife, petitioner, he was filed a complaint before the authority concerned. And accordingly, in that complaint, authority took a view that that complaint was false. And accordingly, against the petitioner, departmental proceeding has been initiated. And pursuant to that, departmental proceeding is imposed with a fine, reduced of pay in time scale. That is the case. And Lordship may last occasion, one inquiry report was called for with regard
Is
to
it there?
Is there? Lordship was on the Lordship will recollect it. Lordship was on what is misconduct. Now, I have checked up, Lordship, in fact, the Act and the CCS rules does not specifically spell out what is misconduct. However, Lordship, I had the occasion of going through a judgment of the Honorable Supreme Court, if I may. Your Lordship will come to page 3 of the judgment.
Yeah.
Because in none of these Lordship rules, I have been able to find out. In paragraph 4, misconduct has been defined so and so. A transgression of some established and definite rule of action, forbidden act, a dereliction from duty, unlawful behavior, willful in character, improper or wrong behavior. Its synonyms are misdemeanor, misdeed, misbehavior, delinquency, impropriety, mismanagement, offense, but not negligence or carelessness. Misconduct in office has been defined as any unlawful behavior by a public officer in relation to his duties of his office, willful in character. The term embraces acts which the office holder has no right to perform, acts performed improperly, and failure to act in the face of an affirmative duty to act. P. Ramanatha Iyer in Law of Lexicon, reprint so and so. Misconduct defines thus: the term misconduct implies a wrongful intention and not a mere error of judgment. Misconduct is not necessarily the same thing as conduct involving moral turpitude. The word misconduct is a relative term and has to be construed with reference to the subject matter and the context wherein the term occurs, having regard to the scope of the act or statute which is being construed. Misconduct literally means wrong conduct or improper conduct. In usual parlance, misconduct means a transgression of some established and definite rule of action where no discretion is left except what necessity may demand, and carelessness, negligence, and unskillfulness are transgressions of some established but indefinite rule of action where some discretion is necessarily left to the actor. Misconduct is a violation of definite law, carelessness, or abuse of discretion under an indefinite law. Misconduct is a forbidden act, carelessness, a forbidden quality of an act, and is necessarily indefinite. Misconduct in office may be defined as unlawful behavior or neglect by a public officer by which rights of a party have been affected. Now, Lordship, here in this case, what has happened is the petitioner, if I may take your Lordship, page 22 of my affidavit, what the petitioner has done, he went to the escort post and he told one Inspector Tulsi Gogoi that कोई सिविलियन गाड़ी आकर किसी की फैमिली को छोड़कर चला गया, आप क्या कर रहे थे, आप लोगों को पता ही नहीं है. So this was said to one of his colleagues who was also an inspector. Now, in fact, a car had gone in and there was a lady in that car. And Gogoi called up the person who had gone in. The person who had gone in was a contractor. He was a Assamese. And he asked, and he told that contractor, মই সেইকাৰণে সুধিছো কাৰ মাইকী থলেহি মাইকীজনী বেলেগৰ আপোনাৰ নহয়. Now, Mikey has been used, Lordship, as it's not something insulting. It connotes a lady. Whose lady have you dropped? Now, this lady herself happened to be the wife of the petitioner. This lady was the wife of the petitioner who was being dropped in the campus, and the petitioner himself says that कोई सिविलियन गाड़ी आकर किसी की फैमिली को छोड़कर चला गया, आप क्या कर रहे थे? That means these people were not aware some civilian car has come in with some lady and has dropped. In fact, it was his own wife. And since this, what this Gogoi has asked over telephone, that was recorded by the contractor, and on the basis of that, the petitioner has filed a complaint. Filed a complaint.
Complaint.
Has filed a complaint.
Oh.
And that complaint, your Lordship will see, is his annexure number 2 at page 26. He says, so some disrespectful words have been told against his wife by Tulsi Gogoi. Now, in fact, he was the one who has complained that a civilian car has.
Where is his complaint? Is it here?
Yes, page,
Complaint,
20,
yeah,
page
yes.
26, annexure 2.
26.
Yes.
Of the petition,
Of the petition.
writ petition.
So what is the name of the petitioner?
Uttam Kumar Mandal,
In the inquiry, was this person's statement recorded? The owner of the vehicle?
If I may take your lordship to the page 22 of my affidavit.
22.
I'll just give a paragraph 7. Lordship will come to E. Hemontapora Rinku stated in his affidavit, stated in his statement that Inspector so-and-so C. Gogoi used the car, it should have been Mikey. Thoi Goisa. And moi he karna kudisu car Mikey tholehi, Mikey joni belegore gore apnar nohoy. So my friend's client is aggrieved by the words Mikey. But that is lordship used in a normal.
If you come to the complaint, where is the complaint?
Complaint at page 26.
This is the complaint.
Yes.
Complaint is based on the statement made in page 27. Now, during the inquiry, it is found that these are not sustained. I mean, cannot be sustained. How does it amount to misconduct?
Lordship, that is why the definition of misconduct. I have not been able to find it in the statute. But lordship, here is something.
Where is the finding that he has deliberately put words in the mouth of the company of this Gogoi,
Lordship.
make it appear that these are derogatory and demeaning for his wife. He has filed a complaint saying that Hemontapora made this statement.
No. He has, if your lordship will come to page 26 once again. But
He said intended to pass utter unscrupulous obscene words.
Yes.
What were these words? He did not specify. You see the accompanying statement.
Yes.
There also it is vague. Uttered unscrupulous obscene language.
Now, he says that my colleague has uttered some obscene words. That is not lordship somebody who is outside the organization. It is his own colleague.
Whatever it may be.
It is his own colleague.
Is he not entitled to raise such an objection? Now, on this particular inquiry, where is the inquiry report of this inquiry?
Lordship will take it up.
All right, we'll come back at 2.
Yes, lordship. I'll place it.
Yes. So we wanted to see the proceeding. So
Lordship.
what happened to this proceeding?
First, if I may draw your lordship to rule 37 of the rules. Under rule 34, lordship, reduction to a lower stage is a minor penalty.
No, we want to know first, before you impose the penalty, there must be a conclusion that
Yes,
there is
yes.
a misconduct.
Lordship.
Now, for that misconduct, whether in respect of the complainant, respect of the person against which the complaint was lodged by the petitioner. He had lodged some complaint.
Yes, Lordship.
Against that person, whether any inquiry was initiated.
Yes, there was a preliminary inquiry.
Is it a part of the pleadings? Preliminary inquiry?
It's
Yes, my lord, preliminary inquiry report is the part of this petition, yeah.
Where is that? Page number?
no idea. No, it's not.
No, my lord, that is not reflected here, sorry, my lord. Just,
I'm just giving a. Oh, excellent. Wait. Conclusion B. It was in Hindi, Lordship. I have got it translated from them. Lordship will come to the conclusion of that inquiry.
Hmm.
Based on the above facts, circumstantial evidence, statements of force personnel and civil drivers, and the analysis of available documents, it is clearly established that on 18/6/21, Head Constable G.T. Susmita Mandal, that is his wife, was deployed for general shift duty at the civil maintenance duty post in the industrial sector. Due to heavy rainfall on that day, at around 15:40 hours, Inspector G.K. Mandal, that is a petitioner, requested Hemanto Bora, Rinku, to drop his wife, Lady So-and-so, to Suraksha Nagar in his vehicle. Hemanto Bora subsequently dropped Susmita Mandal at Suraksha Nagar camp. At approximately 1600 hours, near the escort post in front of the battalion office, Inspector G.K. Mandal told Inspector Tulsi Gogoi, in charge of intelligence section, that a civilian vehicle has dropped someone's family inside the campus and that he, Gogoi, was unaware of it. However, Inspector Mandal himself had earlier requested Hemanto Bora to drop his wife from the duty site at Suraksha Nagar, and he knew that civilian vehicle had brought his wife to the camp. Following this, Inspector Tulsi Gogoi questioned the two civilian drivers and Lady Constable Deepika Borua, who were present at the location. Deepika Borua stated that Hemanto Bora had come in a vehicle, but due to heavy rainfall, she could not see who was inside. Subsequently, Inspector Tulsi Gogoi contacted Hemanto Bora via mobile phone and spoke to him. Thus, it is evident that Inspector G.K. Mandal, despite being fully aware that Hemanto Bora had dropped his wife at Suraksha Nagar camp upon his own request, made an inappropriate and provocative statement to Inspector Tulsi Gogoi, saying that civilian vehicle had dropped somebody's family in at the camp and he was unaware of it. Following this, Inspector Tulsi Gogoi, in order to obtain information regarding the matter, contacted Hemanto Bora via mobile phone during this conversation, and supported by statements and audio recording, it has been found that Inspector Tulsi Gogoi did not use any obscene language and the conversation was carried out in a normal manner. Therefore, the complaint submitted by so-and-so to the competent authority is not substantiated at the first glance. So, now the departmental proceeding against the petitioner was, if I may read the charge,
Yes.
that your
Now,
lordship,
if you come to Annexure 6, page number 31,
Page 31, yes.
This is the, this is a memorandum where there was a proposal to initiate disciplinary.
Yes, the next page is discharged.
I know. So this proposal was mooted by somebody.
Yes, after the inquiry, then this, why it has been proposed, Lordship will kindly read the charge for a moment, Lordship. At page 32. That CSF number so-and-so of industrial so-and-so has exhibited an act of serious misconduct in that he submitted a written complaint on 2/7/21 against Inspector Tulsi Gogoi so-and-so with the allegation that Tulsi Gogoi had uttered unscrupulous so-and-so with intention to insult the modesty of his wife, so-and-so harm her reputation and dignity. Further, it has been revealed on inquiry that the complaint made by Gautam Kumar Mandal is false and baseless, and he had submitted the complaint with a deliberate motive to malign the character of Inspector so-and-so. Such an act of omission and commission on part of Inspector Gautam Mandal tantamount to gross misconduct. Now, he knowing fully well that it was his wife who was being dropped, he says to Gogoi that somebody's family has been dropped and you don't know. And this Gogoi was in charge of the intelligence there.
So this charge is that he has lodged a false and baseless.
Yes.
In the preliminary inquiry, the conclusion is not that. It only says that it is deemed to be unnecessary waste of departmental time. So,
That
see, somebody files a complaint thinking that this is obscene or whatever it is.
no. Lordship, I am not on what is obscene. We will not go into that. Here is a case where
False complaint could be a situation where no such incident ever took.
now here is a case
Here
where
is
he knew.
Where is the case? Here is the case where an incident took place, and somebody uttered something. He interprets this to be an obscene or outraging the modesty.
No, I'm not on that, Lordship. I'm not on that. Suppose he has uttered some obscene words, that law will take its own course.
Right.
Here is a case where Tulsi Gogoi, who was in charge of the intelligence in that particular sector, and
No,
the petitioner comes and says somebody has gone inside, you don't know.
You come to the complaint itself, page number 26.
Yes.
The complaint, it makes very clear that he had instructed Hemant Bora to drop his wife.
Yes.
In the complaint. But the complaint is against this person because he uttered some unscrupulous, obscene word. That is the complaint.
Yes, Lordship.
Now, whether certain words were uttered or not, the inquiry does not say that nothing was uttered or the incident never took place. Inquiry merely said that whatever he has said is not obscene.
Now,
how does it become a misconduct?
No, the misconduct is that by saying that somebody has dropped a lady.
Go by the complaint. Forget what evidence is. It is different. You see the complaint.
No, I have seen that.
Complaint is not on the ground that somebody has dropped and this person was not aware that civilian vehicle had come, not come, etc. He has made it very clear that I had instructed so and so, he dropped my wife. It was a rainy day or something, and then this fellow, he made some unscrupulous obscene. He uttered something obscene word.
Lordship.
Therefore, take action. That is his complaint.
Lordship.
So you may make an inquiry and say this complaint is found to be baseless. How does it amount to his misconduct? How does it become a misconduct? He is entitled as an individual to raise a complaint. If it is not substantiated, dismiss it.
In fact,
how does it become a misconduct?
If I may just make your Lordship to the
plain reading of the complaint.
I have gone through, and even Lordship,
The
if-
inquiry will obviously widen, go into several areas where what we decided, not decided.
I'm with your Lordship. I must say, Lordship, the charge that has been imputed and the findings arrived at by the authority, your Lordship will come to page 35. That's the final order.
35.
Page 35. And if I may take your Lordship to page 38. This is post the preliminary inquiry. At paragraph 3, I've gone through the materials held on record vis-a-vis the contention raised by the charge official in his reply charge memorandum, and observed that there is nothing on record to disbelieve the version of the preliminary inquiry officer. In the preliminary inquiry, it has been established that G.K. Mandal, charged on reaching the escort post so and so, said to Inspector Tulsi Gogoi that कोई सिविलियन गाड़ी आकर किसी की फैमिली को छोड़कर चला गया, आप क्या कर रहे थे, आप लोगों को पता ही नहीं है. Provoking Inspector Tulsi Gogoi to inquire the matter. To inquire.
Whatever it may be.
So, by saying that, you
See, there is no finding in the inquiry that there was animosity between these two persons,
no, Lordship,
prior animosity, therefore he
No,
put up
no.
this story. There's nothing like that.
nothing has come on record,
He
Lordship.
lodged a complaint against somebody. Obviously, when he lodged a complaint, he has some grievance against that person. Whether this grievance is germane or correct or incorrect is a different issue. He has lodged a complaint. Once the complaint is lodged, an inquiry is held. Once the inquiry is held, you find that these are baseless. End of the story. At best, you can perhaps give him a warning or something like that.
Lordship, that could have been done.
But instead of that, you say no, it's a misconduct. Does it become a misconduct without there being any evidence to prove that this was deliberately done to malign this person? That I'm just elaborating on facts perhaps which are not there. That this man is likely to be promoted to the next higher post. So
That would have been a
so that he promoted.
That would have been a, but
This have been this.
I'm with your Lordship. In fact, to be very fair, Lordship,
What has happened to an appeal? You've not gone an appeal.
that has been rejected.
Appeal rejected.
That has been
Yes,
rejected.
appeal, revision, both are.
The charge, the charge, if I may say so, Lordship, the charge does not specifically state that a frivolous
Complaint.
has been filed and that this person was induced to make a inquiry on the basis of a frivolous complaint. It is not there, Lordship. I cannot go beyond that record. Lordship.
We are allowing the repetition.
I think Lordship has to.
Interfering with the punishment.
Because the conclusion arrived at and the charge on two different lines.
Dictated here on heard learned counsel for the Pakistan. The petition is filed for the petitioner to be challenged. The disciplinary proceedings initiated against the petitioner. The order dated 31/3/2022 passed. sorry, order dated 2008-21, passed by the Assistant Commandant / Executive CISF Unit, Oil India Limited, Liajan, whereby the a punishment of, what was the punishment imposed?
Lordship, page 39 is the pay. Page 39 is the relevant page. Reduction of pay by one.
Reduction of pay by 1, see the page 39, paragraph number 4. Hold on, take a look. Stop. The petitioner also challenges the order dated 2/11/2021 passed by the appellate authority, affirming the order passed by the disciplinary authority, as also the order dated 31/3/2022 passed in the revision petition by the Deputy Inspector General, CISF, Eastern Zone, Guwahati. Stop. Para.
There's an appellate order as well.
Yes, the appellate order is 2/11.
211.
The essential facts shown on our unnecessary details are that the petitioner is employed as a CISF, employed under the CISF as and is serving in the rank of inspector in executive wing under CISF ID CISF number 0323000178. Petitioner is posted in the Oil India installations in Duliajan. So, on 18/6/2021, the wife of the petitioner, who was deployed in general shift at civil maintenance in the same Oil India, she was also in Oil India.
Yes.
CISF.
Yes.
As a CISF personnel, was dropped off to her from her duty place to her residence by a private vehicle belonging to a civil contractor. Stop. Prior to the wife of the petitioner getting dropped off, she called up the petitioner and intimated him about that. It is the petitioner thereafter lodged a complaint against one of his colleagues, Inspector / EXE Tulsi Gogoi. ID complaint dated 2/7/2021, alleging that the same CISF personnel, namely Tulsi Gogoi, uttered some obscene words which indicated his evil thoughts and attempted to insult the modesty of our reputation, of our dignity of his wife. So he therefore requested the senior commandant to take suitable step or action against the said Sri Tulsi Gogoi. So the petitioner also attached the call details of the conversation between the petitioner, the said Sri Tulsi Gogoi, one Hemonto Bora, namely the contractor whose vehicle had dropped off the wife of the petitioner, and a voice record between the said complainant, the said CISA personnel, namely Inspector Tulsi Gogoi and Montopora, as well as the statement of amount of stock. Pursuant to this complaint, a preliminary inquiry was conducted, and the authority which conducted the preliminary inquiry, namely the deputy commander, concluded upon careful examination of the materials that the complaint filed by the petitioner is not substantiated, and the filing of such complaint was deemed unnecessary and a waste of departmental time. And pursuant thereto, the petitioner was served with a memo of charge dated 6/8/2020. The memorandum intimated the petitioner that the departmental action under Rule 37 of the CISF Rules 2001 is proposed against the petitioner. Stop the substance of imputation of misconduct, misbehavior, in respect of which the departmental action is contemplated, is enclosed to the memorandum. The petitioner was asked to submit his reply within 10 days. So, the petitioner thereafter submitted his reply, the memorandum, denying all the allegations. Subsequently, by order dated 2008/2021, the inquiry officer, being dissatisfied with the reply filed by the petitioner, the disciplinary authority proceeded with the inquiry by appointing an inquiry officer.
The 37 lordship, it's not,
It's not there.
it's, this is served and he has to give a reply because this is a minor penalty. It does not have to go through the rigors of a full-fledged DP lordship.
You right, the final order dated 2008/2021 was passed by the inquiry officer, holding the charges to be proved and imposing and recommending a penalty of page 39, paragraph 4. So, being agreed, an appeal was filed by the petitioner, which came to be dismissed by order dated so. What is the date of the appellate order?
2/11/2021.
2/11.
2/11/2021.
2021, whereby the order passed by the disciplinary authorities to differ. A revision was also prepared by the petitioner against the award of penalty, which also came to be dismissed by order dated 31/3/2022. Being agreed, the present petition. The council submits. The entire inquiry proceeding was initiated as because the petitioner had lodged a complaint against Sri Tulsi Gogoi. In the understanding of the petitioner, the utterances made by the said Sri Tulsi Gogoi with regard to his wife on the date of the incident, are obscene words and which insulted, which intended with the intention to insult his wife's modesty, reputation, dignity, and to make her feel insecure. So it is submitted that the complaint filed by the petitioner was closed on the ground that the allegations made against Tulsi Gogoi was found to be unsubstantiated. However, the present proceedings, however, it is departmental proceedings against the writ petition was initiated on the ground that he had committed a misconduct. It is submitted that under the provisions of the CISF Act, the rules and thereunder, there is no provision which has been referred to by the Respondent Authority in support of their action, that filing of complaints against police in the services, which if found to be unsubstantiated will amount to misconduct. It is submitted that the article of charge enclosed to the memorandum clearly shows that the complaint lodged by the petitioner against Sri Tulsi Gogoi was found false and baseless, and was with a deliberate move to malign the character of Sri Tulsi Gogoi. So it is submitted that mere filing of a complaint cannot be treated to be an act which can be taken to as a deliberate move malign the character of Tulsi Gogoi as a lady. It is submitted by the counsel to the petitioner that the complaint filed with the petitioner was not a false complaint, and the incident did occur, and the utterances were made by the petitioner, by the Tulsi Gogoi, by the said Tulsi Gogoi against his wife, and which the petitioner, in his understanding, considered it to be demeaning and obscene, and which were intended to insult his wife's modesty, reputation, dignity. At best, the complaint filed with the petitioner can be said to be unsubstantiated, and no further proceedings where may have been carried on. Stop. However, but the allegation that is a misconduct merely because he filed a complaint is totally contrary to, is not supported by provisions of the Act and the rules, and is an attempt to harass the petitioner merely because he had lodged a complaint against one. Anything more? Mr. R.K. Dev Chaudhary, London's PC, hearing for the respondent. This is the complaint raised by the the respondent will file their affidavit raising, disputing the various averments made in the writ petition. During the course of the learned counsel for the respondent submits that there is no infirmity in the proceedings initiated as from a bare perusal of the complaint, as well as the statement of the said Sri Hemanta Bora, revealed that the petitioner was aware of the fact that his wife was dropped off from her duty place to her residence on that particular day. And in spite of that, the petitioner charged the same Sri Tulsi Gogoi that some civilian vehicle had entered the premises to drop a lady, and the CISA personnel, including the said Sri Tulsi Gogoi, was unaware of that. So this is revealed during the proceeding, and from this it is evident that the petitioner was well aware of who was being dropped off in the vehicle and to whom does the vehicle belong. So there is no denial that the lady dropped off was the wife of the petitioner, and she had intimated the petitioner that she will be availing transportation through the private vehicle in view of the prevailing weather conditions, which were which was a very rainy day. Under such circumstances, there was no occasion for the petitioner to question the said Sri Tulsi Gogoi regarding the particulars of the vehicle and the lady who was dropped off that particular day. So that apart, the utterances made by the said Sri Tulsi Gogoi, has been found to be innocuous and not objectionable as alleged by the petitioner in his complaint. It was therefore evident in the inquiry report that the whole complaint, that the complaint made by the petitioner against Tulsi Gogoi was deliberate, knowing fully well it is therefore evident from the inquiry that the complaint made by the petitioner was totally unnecessary and was filed for reasons which are not genuine. Consequently, as a member of a discipline force, the respondent authority considered this to be a misconduct and initiated the departmental proceedings against the petition by issuing the charges. So the petitioner was given every opportunity to participate in the proceeding, and thereafter the charges were held to be proved and punishment imposed. The appellate authority as well as the revisional authority also upheld the punishment imposed and consequently dismissed the appeal and the revision petition filed by the petitioner. Mr. R.K. Dev Chaudhary has referred to a judgment of the apex court, State of Punjab versus Ram Singh, to submit . the term within quotes, misconduct, has have been considered and illustrated by the apex court in single. He fairly submits that the term misconduct is not defined under the Act. Therefore, the general meaning ascribed to the term misconduct has to be referred to, and he fixes reliance that invest text on the judgment rendered by the apex. And counsel for the parties have been heard in the available court and we have judgment cited, provisions of the Act, the rules. The Rule 37 is the procedure mandated under the CI for imposition of minor penalty. Rule 37 leads the extract. The whole episode, the basis of which misconduct is alleged in the petitioner, and the departmental proceedings that they initiate and publish a right of complaint dated 7/2021. Fine. Since the proceedings against the petitioner have arisen from an episode is described in the complaint. The complaint is expected to be complaint is also enclosed by the statement of the civil inspector who's in used vehicle, the petitioner's wife was locked off to her residence. The said statement of the amount of order within bracket ring is also expected below page number 27. During the course of the hearing, the learned DSBI is submitted that pursuant to the complaint being made, there was an inquiry, preliminary inquiry conducted. So the petitioner as well as the various personnel were considered to be relevant for the courses for the purposes of the preliminary were examined. And finally, the conclusion were arrived at by the deputy commander who was appointed as the preliminary inquiry officer. That the complaint filed by the petitioner is not substantiated at the first hand. So, filing such complaint by the petitioner is deemed unnecessary and a waste of department time. We didn't put this preliminary inquiry, however, is not part of the pleading. During the course of the hearing, we learned DSBI Let's please the copy of this. From a careful perusal of the preliminary inquiry, you will see that in respect of the complaint dated brought by the petitioner against upon examination of the witnesses and the documents available, the preliminary inquiry officer concluded that the said Inspector Tulsi Gogoi did not use any obscene language, and the conversation was carried out in a normal manner. So, the complaint submitted by the petitioner was it is held to be not substantiated, and filing such complaint is deemed unnecessary waste of time. The state preliminary inquiry report was submitted for perusal and necessary action of the higher authority. So, pursuant to the preliminary inquiry conducted, the departmental authority has taken a decision to initiate departmental proceedings against the petitioner by issuing memorandum dated 6/8/2021. The memorandum and the articles of charge issued to the petitioner are expected below and reads as under page number 31, 32. So, there are to the said memorandum of charge, the petitioner filed a reply denying the allegation made and substantiating his stand that there was indeed obscene word used by the said Tulsi Gogoi, because of which he had launched the complaint. Subsequently, the inquiry officer held that the charges were proved.
If I may take your lordship to page 39, lordship.
Yes.
It starts from page 38. This is the finding of the disciplinary authority, and I'm taking your lordship to the top paragraph, 1, 2, 3, 4, 6th line from bottom of the top paragraph, lordship, page 39. The charged official had submitted the complaint with a deliberate motive to malign the character. So,
Sorry, page number 39.
39, lordship. The last part of paragraph 3.
Last part. Charged official.
Yes, yes, lordship.
The inquiry officer concluded that the charged official, namely the petitioner, had submitted the complaint with a deliberate motive to malign the charge that the character of Inspector Tulsi Gogoi is undesirable, unacceptable, and a serious act of indiscipline and misconduct in a force like CISF, in a central armed police force like CISF, and attracts suitable disciplinary action. So, inquiry officer concluded that
Lordship, disciplinary authority. Disciplinary authority, lordship.
Disciplinary authority, inquiry officer, disciplinary authority. Oh, this is the disciplinary.
This is the order imposing penalty, lordship.
No, where is the findings of the inquiry officer?
So here, lordship, the full-fledged rigors of that inquiry.
So no inquiry officer was appointed.
No, here they have to give the memo of charge. And he has to make a reply for a minor penalty. For a major,
Is that how is it
Hmm?
provided for?
Preliminary inquiry officers.
No, preliminary inquiry report is there. Preliminary inquiry report is there.
So there is a provision for holding an inquiry.
E-
Is it?
No order imposing any minor penalty specified in 34 shall be made except after informing the enrolled member in writing of the imputations of misconduct or misbehavior on which, so this is given. Holding an inquiry if the disciplinary authority so desires. So that has not been done. If the disciplinary authority so desires in the manner laid down in sub rules 3 to 22 of rule 36. So here the imputation was given and his reply was taken. That was considered along with the preliminary inquiry.
Preliminary inquiry officer also
Yes.
appointed in this case.
So that I have placed. before
Separate
you.
officer was appointed in this case. One Sri Kodarajan, he was the preliminary inquiry officer.
That I have given before your lordship.
And disciplinary authorities, Robi Gupta, different officer.
What was the punishment imposed?
Punishment, my lord,
Reduction to a lower stage in the time scale lordship.
is 39.
That is 2 years. Had it been 3 years, then the rigors of the full-fledged inquiry would come in. Below 3 years, it is not required.
Illegal, ಅಲ್ಲ? Disciplinary authority concluded that making false and baseless allegations against a colleague amounts to an act of grave misconduct, particularly in the facts and circumstances wherein it was revealed in the preliminary inquiry that he provoked the said Inspector Tulsi Gogoi inquiry into the matter, despite being fully aware of the entire facts of the case. And consequently, the punishment for reduction of pay was punishment was imposed. As per the provisions of Rule 37, for imposition of minor penalty, the procedure has been carefully delineated to the say rules. So, where the withholding of pay and withholding of increment for a period of exceeding 3 years or with cumulative effect was imposed as a punishment, then an inquiry is required to be held. So, otherwise, under Rule 37(1)(b), the inquiry may be held only if the disciplinary authority so desires. Fair enough. From a perusal of the memo dated 6/8/2021, read with the article of charge, you see that the charge framed against the petitioner is that he made a false and baseless complaint against his colleague, Inspector Tulsi Gogoi, with a deliberate motive to malign the state officer's character. And therefore, such an act or omission on the part of the petitioner tantamounts to gross misconduct and discipline, which is unbecoming of the discipline subject of the law. The perusal of the final order in by the disciplinary authority does not reveal that there was any false or baseless allegation, does not uh, bring out any evidence to substantiate the stand of the department that the allegation made against the said officer Tulsi Gogoi was false and a baseless allegation which amounts to grave misconduct. The complaint filed by the petitioner against the said Court Inspector Tulsi Gogoi clearly revealed that the petitioner was aware of the fact that his wife was dropped off in a private vehicle within the Oil India premises from her place of duty to her residence on 18/6/2021 at about after completion of her duty at about 15:40 hours. After completion of her duty hours. And prior to that, she had intimated the petitioner that she wanted to avail. She wanted to be dropped off in a vehicle because of the heavy rain and the fact that she forgot to take her raincoat, and the scooty was also not working properly. So it is further alleged in the complaint that the said Sri Tulsi Gogoi spoke to the said Sri Hemanta Bora and intended to utter obscene words which affected his wife's modesty, reputation, dignity. The statement of Hemanta Bora is enclosed to the complaint also reveals that the said Sri Tulsi Gogoi had called the Sri Hemanta Bora and passed an unscrupulous, obscene language which clearly indicates of having evil thoughts and intended to insult the modesty, reputation, dignity of the wife of the petitioner, as well as put a question mark on the character of Sri Hemanta Bora. The statement of Sri Hemanta Bora is signed, and it is shown to be signed 1/7/1. Under such circumstances, it's evident that the complaint of the writ petition in respect of Sri Tulsi Gogoi was in respect of utterances of obscene word, which the petitioner believed was intended, uttered by the say Tulsi Gogoi, and was intended to harm the reputation, dignity, and modesty of his wife. And this complaint is supported by a similar statement signed by the person who had dropped off his wife that day of the incident, and with whom the said Inspector Tulsi Gogoi had telephonic conversation. So the same signed statement also revealed that the said Sri Tulsi Gogoi had called up the said Sri Hemanta Bora, his telephone, and uttered obscene languages intending to insult the modesty of his wife, the petitioner. Modesty of harm the reputation, dignity of the petitioner's wife. There are therefore, from a mere perusal of the complaint, read with the statement at close, revealed that the petitioner had lodged a complaint against his colleague on his understanding that the words uttered by Tulsi Gogoi were obscene and were intended to harm the modesty, reputation, dignity of it. On the contrary, the preliminary inquiry report, which is placed before the court, also reveals that such an incident did take place. However, on careful examination of the witnesses and the materials placed before the inquiry officer, preliminary inquiry command, it was concluded that the complaint submitted by the petitioner is not substantiated and was deemed unnecessary and a waste of department. There was no finding in the preliminary inquiry that the complaint lodged by the petitioner was false or baseless or baseless allegations were made against the colleague. To malign the character of the said Tulsi Gogoi. So, the memorandum along with the statement of allegation, statement of article of charge, referred to the inquiry on the complaint filed by the petitioner, holding that the inquiry revealed that the complaint made by the petitioner is false and baseless, and the complaint had been made with a deliberate motive to malign the character of the said Sri Tulsi Gogoi. However, the perusal of the preliminary inquiry form does not reveal that any such finding has been arrived at by the preliminary inquiry officer in the inquiry. Stop. Under such circumstances, it is evident that the entire proceedings initiated against the petitioner is based on the inquiry within bracket preliminary inquiry made and the findings of such inquiry that the complaint by the petitioner is false and baseless with a deliberate motive to malign the character of the said Sri Tulsi Gogoi. Stop. However, no such finding is revealed in the conclusions arrived at by the inquiry officer. Stop. That apart, in the absence of any specific provision under the Act and the rules, specifically defining within court's misconduct, the disciplinary authority is required to refer to such instances or evidence which can be construed to be misconduct after such opportunity is granted to the writ petition. Stop. The entire inquiry report is found to be largely dependent, largely based on the preliminary inquiry which was conducted against the petition. There is no finding by the inquiry officer as to how the allegation of misconduct against the writ petitioner is substantiated, and as to whether the act alleged to have been committed by the petitioner will be covered, will be within the domain of the term misconduct in the absence of any such specific provision under the Act and the rules. So, no reference to any authorities is found to be cited in the inquiry in the order passed by the disciplinary authority to substantiate its conclusion that the actions or inactions of the petitioner can be and is required to be construed misconduct, and which entails the punishment imposed. The judgment referred to by the ESGI clearly examines the term misconduct under finds misconduct, examines misconduct as per the definition given in Black's law, as well as law lexicon. Relevant portion. There are 4. Stop. The only case against the only case predicted against the petitioner is that he had lodged a false and a baseless complaint against his colleague Siguboi with an attempt to malign his life. This, the opinion of the board, is not seen from the facts narrated above discussed. The such circumstances, this court is inclined to allow the writ petition. The impugned order of penalty dated so and so, along with the orders passed by the appellate provisional authorities, are hereby declared with and set aside. The petitioner will be entitled to his full service benefits with effect from the date of imposition of the order of penalty.
Well,
Petition.
if I may just point out, Lordship, Lordship was referring to the preliminary inquiry, the conclusions, the second paragraph, subparagraph. It is thus evident that Inspector so-and-so, despite having fully aware that so-and-so, now it starts from here, Lordship. In spite of the petitioner knowing that his wife was being dropped, he makes a statement that
What we are saying, that is there in the complaint itself.
no,
Evident from the complaint.
it
That is
is,
the way.
this is not there, Lordship. In the complaint, he says straightway But in the check post, he goes and says that a civilian vehicle carrying a lady has gone inside. What are you doing? And for that, Gogoi has
What are
made an
you-
inquiry.
What are your allegations against the petitioner? Your allegations against the petitioner is that he has not provoked or his colleague. That's not the allegation.
Yes,
Allegation is that you have filed a complaint which is false and baseless.
yes,
What is the complaint?
Lush, lush.
The complaint is that such and such incident occurred and this is the statement he made and he enclosed the statement of that contractor signed statement.
Lush.
And the contractor says he not only made allegations against her, he is raising questions on my integrity or character. So the complaint is there. So there was an incident. It can't be a fault. The only question of controversy is whether whatever he has uttered is obscene or not.
Lush.
There was no finding to that effect, technically.
Lush.
And if there was a finding, then the only conclusion is that complaint is not maintainable, which has been held in the preliminary inquiry.
Yes,
Now, how does it become a misconduct?
yes.
Only on that as nothing.
So nice.
obliged. Also,
May I please, your lordship?
Yes. Where is your counterpart?
Yes, your lordship.
What have you?
My lord, the specific queries were posed on last occasion, my lord. That information has not been given by the department, in spite of me communicating that I need this information, my lord. They have not given me that.
It is to be submitted to whom?
Two things, my lord. One, whether the review orders were communicated or not. That has not been clarified by the department. Second, my lord had given that that OM says that personnel department needs to be given periodic information about the status of the departmental proceedings, whether that has been done by the department or not. I want both these information, my lord, they have not given to me yet.
So what is your submission?
If some time, but perhaps petitioner is also has an urgency, my lord, but
When are you-
otherwise.
Your lordship, 31st of July, your lordship, there is also an observation that if the state respondents fail to obtain instruction, consequential orders might be passed, you know.
What do you say regarding the judgment which was referred? There are judgments passed by this court
Yes, your lordship.
interfering with suspension. Do you have a copy of those orders?
Lordship, dealing with which aspects, your lordship?
Interfering with disciplinary, suspension order.
Yes, your lordship, I have produced a few judgments, your lordship. There are judgments where this honorable court has held, and there is one more judgment, your lordship. I have placed all the judgments, your lordship, in the same department, your lordship. There was this case where I had appeared, your lordship, where show cause notice was served and review was not done within the period of 90 days, and that suspension order was set aside, your lordship. I placed on the 17th of June 2025, submitted before Iqbal Ahmed, your lordship.
It's not here.
Yes, your lordship.
So we are asking you, there are judgment by this court interfering with suspension. And copies of that.
Your lordship, I have one judgment, your lordship, interfering with suspension orders, your lordship. Pardon, your lordship, I have placed the office copy, your lordship. Pardon me for that.
That's all right. We have one copy of this.
Yes, your lordship.
What is to be done, yes?
If my lord may fix it on a Friday, my lord, I'll try to get concrete instructions on this one. And well, if I don't get anything in affirmative, my lord, it can be assumed that both the answers are in negative, my lord, if they don't communicate anything to me.
Your Lordship, my only humble submission is that there was an ample amount of time which has been granted, Your Lordship, during the vacation, Your Lordship. And there's a specific observation by this honorable court, Your Lordship, which they have not yet.
Let us give him one more opportunity. Monday?
Your Lordship, this week, Your Lordship. Otherwise, Your Lordship, the whole exercise would be a.
All right, Friday.
Friday.
It's on Friday. The prayers made by Mr. Portahood, Larat, standing counsel Forest. Praying for further time to complete the instruction in terms of the earlier order dated so and so. Twenty-five, 6. 35.
Your Lordship, I pray for an earlier date if it's possible for Your Lordship.
Friday.
Friday.
Today is Tuesday. What early dates do you want?
Perhaps, Your Lordship, on.
We can
Thursday.
dispose it off. We are just giving him one opportunity to get the instructions.
Yes, Your Lordship.
Otherwise, it is as good as passing an ex parte order.
Yes, Your Lordship.
Friday.
Lordship, I have researched on that particular aspect which Your Lordship had queried on the last occasion, Your Lordship, whether the communication of the review order. However, Your Lordship, as far as my research is concerned, Your Lordship, I haven't found any judgments, but there has to be an order which has to be communicated, otherwise it's not good in law, Your Lordship.
We'll examine that.
Yes, Your Lordship. Much obliged, Your Lordship.
Okay.
Yes,
Challenges to an order of dismissal.
I think we should defer it now,
My lord,
Mr. Muzumdar.
my lord.
We should defer it for some time. To enable him the alternative arrangement. That will be listed after 1 week, 2 weeks.
Obligation.
Request made by the council.
Obligation.
May please, Your Lordship. Actually, the challenge here in this case is that when advertisement was issued by the respondent authorities, calling Lordship for the post of Forester grade 1, Lordship will find the advertisement at page 20.
Yes, Mr. Botago.
Yes. And we have received the records. There was a prior litigation. The leading case being, my lord, writ petition 1424/2016. In that case, my lord, same advertisement was challenged by some other parties, not a party to this case. They were contending that women's reservation law was not properly followed in this recruitment. So therefore, based on that, my lord, 30% blanket reservation on all categories was made. And after doing that, my lord, these these private respondents in the current case, they were selected under OBC women category, because 30% of all categories had to be reserved. And that is why these private respondents were selected under OBC women category, from what I can see from the records.
Yes.
Lord.
You're challenging the selection and appointment of
Basically,
private respondent.
private respondent, Lordship, as well
Who are
as
representing the private respondents.
They might never
notice
appear.
was issued, Lordship, but they have not appeared.
They're not appearing. in this. They should, my lord, for assistance of this court. I don't know why, my lord.
If not appeared, what can be done? But is service complete on them?
Service complete long back, Lordship. Lordship, out of this private respondent number, four,
Deemed
five,
to be
eight.
complete.
Yes, deemed to be complete, because it was
Where are they posted now?
that will, Lordship,
That, my lord, I have to inquire. In them. They are forester grade 1.
You take steps to them.
Lordship,
You're questioning their appointments,
no, as well as the Lordship entire selection proceeding.
whatever it is.
Yes.
Maybe. You are seeking interference of their appointment.
This, yes.
So you take steps.
Yes,
If
sir.
deeming service will not do.
The Lordship notice was issued, Lordship, it was,
Maybe
yes,
the service was complete.
but now proper it is now, Lordship, perhaps Lordship
We
responding
can,
and provide.
my lord, we can do it through our office. We can again send copies of the case.
Who will serve copies? Who is the authority who will serve copies?
PCCS office can be, my lord. We have done it in previous case.
Then you'll have to file an affidavit saying that it has been served.
My lord. That,
Whoever who is the officer who is serving them will have
Yes,
to file an affidavit that in
Mm.
terms of the directions issued by the court, copies have been served. And, on so and so day.
if required, we'll do that, my lord.
It has to be.
Yes.
Otherwise,
Otherwise, yes.
what is
Some
the
questions
basis on
will-
which you serve copies? Who will
Right.
give the responsibility?
Lord.
Where are they posted now? You don't know.
I don't know, my. I can get that information.
You get it. 5, 6, 7, 8. You get the information. Monday,
Monday, I'll get the information.
let it be on Monday. Counsel for the Forest Department will obtain instruction. The present cases of posting of respondents 5, 6, 7, 8. 5, 6, 7, 8. As none, as in spite of the service deemed to have been affected by the laws in the court by order dated 10/3/2023, none represents same response. On the court being apprised of the present places of posting, the petitioner will take steps to the department, and the concerned officer in the department will also file an affidavit. After service of copies. Based on Monday.
Hmm.
20.
Lord.
Public.
Public.
This will now come for orders, please for orders. Matter be listed for orders or not?
Lord.
Well, as per the earlier order, my lord, I was directed to produce the relevant portion of the record to show the role of respondent number 5 in the decision-making process with regard to the replacement of the writ petitioner. This downloaded copy of the file. Record of this, solve করা। In fact, this letter dated 17/1/2024 that was issued by the respondent number 8 at the regional office, my lord. Here at
Who
Guwahati,
is the respondent there?
my lord. He is the controlling and my lord
reporting officer of the writ petition, respondent number 8.
So the respondent number 4,
Formal allegation against him,
no, in this order,
Lordship.
respondent 4 is the first signatory.
My lord, he has, my lord, on the basis of the, my lord, the replacement letter dated 17/1/2024 that was communicated to the headquarter in the administration department. That letter 17/1/2024, Lordship will find at page 50 of the writ petition. He just made the note for onward transmission to the higher authority for approval. He was not a part of the decision-making process as such.
And who, on what basis this note is being put up? Found to be unsatisfactory?
No, that is by the respondent number 8 from the regional office.
So what is that basis? What is the basis of the conclusion that it is found to be unsatisfactory?
It was this has that letter, my lord, 17/1 also indicates, my lord, the approval of the ED, my lord.
See, this is by the general manager P.
P.
Personnel perhaps.
Project, my lord.
Project.
Project. She was appointed against the project.
Very well,
Lord.
but there is a opinion by the general manager that her performance is found to be unsatisfactory.
Lord.
That must be on some material.
That is normally as a subject.
Foundation is reflected in the affidavit. There's no foundational basis for these orders.
That is the, my lord, subjective satisfaction of the authority because.
How can it be
Lord,
subjective satisfaction? You are dealing with human beings.
my lord, in that case, my lord, I have to, my lord, look, my lord, ask for if any there is any other, my lord, records, my lord, with regard to the regional office, my lord.
Has to be.
But
Well, there is one aspect.
See, this note is very clear. Performance, including coordination, is found to be unsatisfactory.
look, the basic your lordship will find in the writ petition, it is not this letter of 17 or 19 are not under challenge. Challenge is the letter issued by the outsourcing agency who has terminated. We did not terminate.
Clearly, you did not terminate, but
Lordship.
you gave an opinion.
That we
This
needed,
is
we
not
need a replacement, my lord.
Huh?
We need a replacement.
That's right.
And accordingly,
That is
replacement has been done.
terminated because these are being outsourced. The moment you say that, no, sorry, we don't like you, it's unsatisfactory. Some cases,
Now the whole, my lord, the contention of the writ petitioner that as because there was a, my lord, complaint before the ICC with regard to the harassment against this particular person, he, my lord, as a, my lord,
so therefore you show us the record
lordship.
on the basis.
Well, there are no
of
such
the
records.
Manager projects has returned a finding that it is unsatisfactory.
My lord, the allegation is against the respondent number 4.
But we want to see
Lordship.
why are you shying away?
No, we're not aware. Since on the earlier occasion, Lordship wanted to see the role of the respondent
I
number.
know that you don't have it. Call for the record. Let us have a look.
Yes.
Well, there's one aspect in this matter I would like to bring to your kind notice. As an officer in the court, my lord, it's my duty to bring to your notice this letter. After hearing the last arguments and the questions that were raised by my lord, the respondents have now given me an offer that you join our establishment and withdraw this writ petition. So this is the latest offer that I've received from them just 3 days prior to.
So you go and join.
Well, the problem is that right now negotiations are taking place between my client and NHIDCL, whether they are also willing to withdraw the two impugned termination orders dated 17/1 and 19/1. So my lord, give me a week's time.
Counsel for the parties.
Just need week's time to get back to you, my lord.
Petitioner, there is some parley between the petitioner and the respondent.
Just give me a week's time, my lord.
Seeks some time to complete his instruction with this regard to be listed after 2 weeks. 2 weeks. Obliged. Mr. P.J. Soikia, Senior Counsel, assisted by M. Nirol, APS for the respondents.
And in case, my lord, if they do not agree, then we'll have to get into the merits. And
After 2 weeks.
Sure.
See,
May I pay for a date, my lord, on sometime on
2 weeks.
20th August. 20th August, my lord,
28th August.
20.
2-0.
2-0 is not
Then-
2 weeks.
Huh?
It will be more than 2 weeks.
It will be more than 2 weeks, my lord.
No.
Hardly take a week's time, my lord, to get the instructions whether they have achieved.
So we'll have it on 11th August.
11th.
11?
11th is fine.
I'll have little problem, my lord, if on 13th, my lord. Yes,
13th already.
My lord, one short thing that I would like to bring to your notice. My lord, on 13th, let them produce all the records on the
You
PC.
first come up and tell us if your client is ready to accept that offer. Why should we go into all these
My
aspects?
lord, but the problem here is that the acceptance of this offer is completely different from the prayer here. The prayer is withdrawal of these two orders.
We are now recording in the order that you have prayed for time to get instructions, whether, what is the status, whether they're going to
Absolutely
offer or
right.
not. You come back with these instructions. Say. Yes.
Let's.
Yes. Mr.
My lord, I am not appearing for respondent number 11. Let's say I have recorded for all the respondent.
1
Yes,
to 10,
respondent
12.
number
1 to 10 and 12.
1 to 10 and 12. Anyone for 11?
Name has been shown, but did not appear on the earlier present also.
1 to 10 and 11. None represents respondent 11.
Here, my lord, petitioner was initially appointed as a vice chairman of the post Rajbangshi Development Council.
People are already working.
My lord. No, my lord.
I have filed the affidavit yesterday, Your Lordship, bringing on record the document that 2 vice chairmen are already working.
My lord, let me file a reply to that, my lord, because I have some documents to show, my lord.
Right. MS R. Dega, Learned Standing Council for the Social Justice Empowerment Department, submit an affidavit, additional affidavit has been filed yesterday.
Yesterday, 14.
Said affidavit, however, is not on record. Registry to trace out the affidavit and bring it, connect it to the case record. So, Mr. Deka, Kolita, on the other end, submits that you would also like to file a rejoinder, the additional affidavit. He prays for 2 weeks.
My lord, on this, can it be on 28th, my lord?
Right.
Yes, my lord.
He prays for 10 days time and therefore be listed again. That is agreed to, and therefore be listed again. 28th of July.
Yes, ma'am.
28.
Yes, ma'am.
Obliged.
Obliged, ma'am.